for listing a motion matter on 20th, my lord.
20.
Please, your lordship. Item number 47 lead to accommodation at 2, my lord. I am difficulty in division bench.
At 2, 47.
47 motion, my lord. Can you be?
I beg to mention item number 35, my lord. Let it be after.
Mr. Sharma, you have to meet me. Okay.
Item 35, my lord. I am for the respondent. I have taken the consent of the other side. Later may be listed after BU petition. NCR has come. I have need to go.
Okay. Miss
M. Burman.
M.
M. Burman.
M. Burman, learned counsel for the
Sole respondent.
sole respondent. Says that the matter may be listed after the vacation. As NCR has arrived.
Right.
List the matter after the vacation.
Obliged.
Please, Lordship. Lordship, with due consent from the other side, I beg to mention item number 21, Lordship. Mr. Kian Chaudhary is leading the case. He has some problem today, Lordship. So after
Okay, right. On the prayer for adjournment made on behalf of Mr. K. Chaudhary, this is the matter after vacation.
Made to Lordship. This is urgent matter. Tender matter. Tomorrow is the date for opening. If Lordship allow me today itself at 2 o'clock.
Okay.
Lordship, for listing for motion for on 20th member. Obliged.
Same prayer, my lord.
20.
My lord, in respect of item number 30, I am appealing on behalf of Mr. S. Dekar. My lord, there is no private respondent in this matter. Can the matter be taken up after vacation, my lord?
Item 30.
Item 30, my lord.
No, the affidavit has to be filed.
Yes, my lord.
Okay, right. On the prayer made on behalf of Mr. S. Dekar, list the matter after vacation.
And there is an interim order that may be.
Interim order to continue till the next day.
May I plead,
Your Lordship, I beg to mention for listing two read petition, Lordship. Tomorrow, Lordship. New Lordship, motion matter already, similar matter already decide this issues.
Okay. Okay, huh?
Tomorrow,
No
Lordship.
problem.
Motion matter, Lordship. Already,
Decided matter, covered matter, covered matter.
Lordship. Building, regarding building permission, Lordship.
Okay, that 2% forest royalty.
Lordship, Lord. Much obliged.
May I please, your lordship? Lordship, a concern on the other side, beg to mention item number 16 and 17, your lordship. Let the matter be taken up after vacation, your lordship. And item number 16, we have filed our affidavit.
16 and 17.
16 and 17.
Who's for the other side? I thought of disposing this matter.
But we need to file one affidavit, item number 17, your lordship.
You have to file.
Yes, 17.
Okay. Mr. R.R. Gogoi, learned counsel for the petitioner, is granted
2 weeks time, your lordship.
2 weeks time to file affidavit in WPC 2798 of 2023. This is the matter after 2 weeks.
Obliged, lordship.
May I please, your lordship, I'm for item number 12. Kindly list the matter after the vacation.
Who are you, madam?
Yes, I'm on behalf of MSB Chaudhary.
B. Chaudhary.
Yes,
Miss
Imsen Kala. Imsen Kala.
spelling.
IMSENKALA.
Miss Imsen Kala. Praise for adjournment on behalf of Mr. B. Chaudhary.
MSB Chaudhary.
Miss B. Chaudhary. Praise aloud. This is the matter after the vacation.
Lordship.
Yes, madam.
Lordship, this matter may become infectious.
Which item?
Item 2.
Very stiff. I got shocked. Okay. Item 2. Okay. Okay, so completed fishery that has been made.
I think. I don't have instruction, but they are.
Okay, right. Miss
FH Ahmed.
F.S. Ahmed.
FH.
Huh?
FH Ahmed.
F.H. Ahmed. Learned counsel for the petitioner submits that the writ petition has become infructuous. Accordingly, the writ petition is closed as infructuous.
May I plead, your lordship? I beg to mention a fresh writ petition for listing on Friday, lordship.
May I please, your lordship? I beg to mention for listing for tomorrow, lordship.
Fresh,
A fresh-
new.
Yes, lordship.
What is the matter about?
It's about relating to a temple, lordship.
What about it?
I'm not so much aware of this, lordship.
No,
but
madam, you've got to tell me whether it's urgent or not.
It's like dispute of like the temple, lordship. some relating to temple lordship.
No, madam, you see, bench, this is a bench 4 case. So temple, what has temple got to do with it?
Bench for
Bench 5, bench 4.
eviction. Is it eviction?
The temple matter, how can it be eviction? I don't know.
Eviction is bench 5, my man.
Bench 5.
Demolition and eviction.
You go to bench 5, madam, this is bench 4.
The lordship tender matter, your lordship, complete matter. Should go
So when?
Friday, your lordship.
There is for motion item 1.
May I please? Lordship, kindly see the last order dated 13/11/20.
My lord, in this matter, our letter is serious, however, they have not supplied the copy, my lord.
Huh?
They have not supplied us the copy, my lord, service.
Extra copy of the writ
Yes,
petition.
my lord. I mean, they are not.
Yes, how can you apply for this allotment of rooms? What is your right? You apply, you go and get the thing.
Lordship, kindly see the 2024 orders, Lordship. This instruction is required, Lord.
Huh?
Your Lordship asked to receive instructions, Lordship.
Yes, Mr.
That
Bokale,
may
was
be seen,
supposed to.
Lordship. 13/11/24
Yes, my lord.
may be seen, Lord.
You see, they are going to say that 5 lakhs is not being demanded.
Lordship, they
When this application, what is the last date of submission of application?
Lordship, we have not applied for the same, Lord.
Then,
Lordship, we are.
Acha, you see, whether the rooms have all been allotted or not.
Yes, Lord.
We have no instruction at all, my lord, because the extra copy not supply, we could not contact the my lord. The concern.
You could have easily called him up. Why are you acting like a Bara Babu? I do not have enough information. Please understand, there's a difference. You see, the office has got certain procedures. This is a court.
My
I do not have enough papers. What is this?
my dear.
Another date may be fixed and let them collect the information.
You give the extra copies also. Mr.
80 Sharka.
Huh?
80 Sharka.
A.T. Sharma. A.T. Sarkar, learn counsel for the petition, shall submit extra copies of the writ petition to Mr. G. Bokaliar during the course of the day. Mr. G. Bokaliar shall obtain instructions in terms of the order dated 13/11/24. This is the matter on. If
Your lordship, my lord, I have received the granted. In the relevant portion, I have flag marked the pink flag, my lord.
so the vessel cannot be found.
Yes, and conclusion part, my lord, make conclusion part. Vessel was not there. It is
Now what is to be done? So either it is taken out.
yes.
Now whose fault it is? He did not take it within time.
Within time.
Now what is to be done?
My lord, may what appropriate order?
Huh?
Lordship may pass.
No, appropriate order will be, what will be the appropriate order?
The lordship kindly permits me, can I submit
Uh,
something? It is not the issue that I have not taken the vessels within time. Your lordship have categorically stated that I prayed for an extension and that the extension was prayed because the vessel could not be traced on that day. And accordingly, they have given me 2 months extension. And during the period of the extension, the validity of the extension period, the IWT has issued me with the delivery order. And thereafter I have gone. Again, I found it was not there. It is not a case that I have deliberately not taken it.
Then how much money has he given?
8 lakhs 1 rupees. I'm not.
So you return the 8 lakhs or what?
Yes, your lordship.
Lordship may kindly observe, since they have deposited the money in the government exchequer, it is not with the direct rate. This it takes some time to release the amount. In the next budget session after March, we will return them.
Your
Lordship may
Lordship,
kindly have.
I have already stated that this is a youth unemployed with those who are doing small time businessman.
No, not
It's
it is not our fault also. Lordship may
It is
kindly
not, you see,
observe.
Mr. Council, you see, everything is, you're not the person, the person without any fault.
Yes.
It is because of you not taking the vessel in time that this has happened. So don't think that
Yeah.
you are holier than thou and they are all at fault. It is you, because of you this has happened. You should have taken it within time. You asked for time, they gave you. In good faith, they gave you. It is not that
I
it's
agree
not
with your
that
Lordship.
it is their fault, it is your fault.
Your Lordship, but the vessel could not be traced.
Mr.
Therefore,
Council, please, it's enough. Otherwise, I'll list it next year. We'll decide. You file affidavit. Issue
Your
notice.
Lordship can pass this an order in that.
What do we give you an inch, you want to take a foot.
And we have also not
As if
objected.
that you're the only one who is right. They are all in the wrong. What is this? Be fair. I think you should file affidavit.
Lordship. The Lordship may kindly issue notice.
Yes.
Other parties are also there.
MSTC, the notice should go in.
Huh?
MSTC, the notice should go.
I-
1 and 2, they have to take steps. ma'am.
Heard. Mrs. R. Sinha, learned counsel for the petitioner. And Ms. D. Bora, and Ms. M. D. Bora, learned counsel for the transport department. In terms of the order dated 13th of 2024. A joint spot verification report dated 15th of 2024 has been issued, which is to the effect that the vessel MV Cumming is not anchored, and it appears that the vessel is submerged and within the depths of the river. So the petitioner's counsel submits that as the petitioner cannot be able to take delivery of the vessel, the auction amount of rupees
8 lakhs.
1,000,
8
One.
lakhs, 1 rupee.
8 at 1, 8 lakh 1 rupee should be returned to the petitioner. Issue notice returnable in 3 weeks. Ms. M.D. Bora, learned counsel for the respondent number
3, 4, 5, 6, 7, 8.
3 to 8.
Sure.
Shall file affidavit within 3 weeks.
Lordship.
Who is for 1 and 2?
They have to take steps, my lord.
Yes, Your Lordship.
Petitioner takes steps for service of notice upon the respondent's number
1 and 2.
1 and 2. That's all, 1 and 2.
Lordship.
1 and 2. By registered post daily within 3 days. This is the matter. After 3 weeks.
Deeply obliged. Lordship, may I get back the report?
Yes, yes.
No.
You make it 4 weeks, returnable 4 weeks, because it will take some time. Holidays are there.
Obliged, my lord.
Please, Your Lordship, my lord, this matter relates to non-issuance of IMFL off-shop license, my lord. The petitioner had already
What to do?
submitted their.
Lordship, at this point, with our instruction, I cannot supplement anything. Let notice be go, Your Lord. Let notice go, Your Lordship. That will-
Yes.
Miss S.B. Chaudhary, learned counsel for the petitioner, submits that the respondents have not taken a final decision with regard to the application made by the petitioner for issuance of a IMFL off-shop license. She also submits that the petitioner has deposited a challan of rupees 1 lakh in pursuance to the same. Issue notice returnable in 4 weeks. Ms. R.R. Gogoi accepts notice on behalf of
Respond number 2, 3, 4, 5, 6, 7, 8, 9, 10, 12, 13, 14, 15, 16, except 1 and 11.
all the respondents except 1 and 11. Mr. G. Bokalel accepts notice on behalf of
1 and 11.
respondents number 1 and 11. This is the matter after 4 weeks.
Pendency of this petition may not be a bar to
Pendency of this petition shall not be a bar for the respondents to
complete the. process.
decide, take a decision on the petitioner's application for grant of a IMFL off-shop license.
Obliged, Lordship.
Okay, heard Mr. S. Thakur, learned counsel for the petitioner who submits that the vehicle hire charges of rupees 57,30,250 has not been paid. Mr. G, except issue notice returnable in 4 weeks. Mr. G. Bokalial accept notice on behalf of all the respondents. List the matter after 4 weeks to enable the response to file the affidavit.
Thanks.
Okay, heard Mr.
Ajay Dabas.
Huh?
Ajay Dabas, Your Lordship. My name would not be there. I shall be filing my wakalatnama. I was engaged yesterday only. My associate's wakalatnama is there.
What's your name?
Yes, I can.
Mr. S.J. Saikia, heard Mr. S.J. Saikia, learned counsel for the petitioner who submits that the petitioner's road construction dues amounting to rupees 5,07,80,954 has not been paid. Issue notice returnable in 5 weeks. Ms. S. Kemprai accept notice on behalf of
Lordship, if I may, they have not made the principal secretary, Karbi Anglong is party here. He's a necessary party. Autonomous council, they have not made a party. And secretary, PWD Lordship. Autonomous council. Those are necessary parties.
Mr. Counsel, what you do is just thing. Instead of filing a impleadment application, allowing the application, filing again a corrected cost title, you withdraw and file afresh.
Lordship,
It becomes easy.
kindly allow me to implead because already.
Okay, then we won't issue notice now. Then you implead everything, then we'll do.
But I will withdraw then.
Better, it's easier, but tomorrow you just change just 1-2 pages, that's
Please,
all.
Your Lordship.
Mr. P.J. Saikia, learned counsel for the petitioner, please that he may be allowed to withdraw the writ petition with liberty to file a fee. The press allowed, writ petition dismissed as withdrawn, with liberty as fixed.
Lordship.
Mr. M. Sharma, learned counsel for the petitioner submits that the petitioner's contractual dues amounting to rupees 180 lakhs. 180 lakhs.
No, 1 crore 80 lakhs.
So there's a difference. Is there a difference between 180
No,
lakhs
I
and
did not hear that. I'm sorry. Apologies. Your Lordship, the matter may be tagged with
180 lakhs has not been paid? Issue notice returnable in 4 weeks. Mr. B. Chowdhury accepts notice on behalf of
Except respondent number 2.
all the respondents except respondent number 2, who is represented by Mr. P. Nayak. Accordingly, list this matter after 4 weeks to enable the respondents to file their
the
affidavit.
matter may be tagged along the similar matter of the similar process.
Huh?
The matter may be tagged with WPC number 3903.
List the matter, tag this matter along with WPC.
3903.
Lordship, that case is listed today,
Okay.
but that is in respect of Assam Sikh Corporation.
No, there is a difference. There is a difference. Your Lordship will
Let
tag-
it next. No, sir, tag. What does it matter? Right, heard Mr. S. Thakur, learned counsel for the petitioner. The vehicle hire charges, huh?
Yes.
18,72,535. Then Mr. Bokalel accepts notice on behalf of all.
All.
Same thing. Heard Mr.
M. Saikia.
A. Sharma, learned counsel for the.
Lord.
A. Saikia. Your name is not here.
Here, Lord. Means
Huh?
Saikia. Mention it means Saikia.
Acha, item 46.
Yes.
Oh, okay. I was looking at something else. Okay, that repossessed.
Yes.
Is there any judgments of the Supreme Court?
Yes, Lordship. Honorable
No, the latest ones, not the old ones.
latest one, Lordship, 2020, Lordship, one judgment has been passed. Lordship. Yes, Lordship. Messrs. Mekma Finance Co. Limited.
Yes.
Mekma,
What does it say?
Tiwari.
What does it say?
Lordship, wherein stated that not to recovery repossess the vehicle by using guns or gundas law.
No, I think there is some other judgment now. Because you are not the owner of the vehicle.
Yes,
It's a
absolutely right.
hypothecated vehicle. Your
That lordship,
hypothecation
that's
means
a
it,
procedural
yeah,
lordship.
the
Procedure
owner is
also
the
always follow that lordship.
owner is the
In the
finance.
lordship, master circular has been issued by the Reserve Bank of India. Reserve Bank is the financial bank, parent authority of every financial bank lordship. There's a master circular has been issued wherein guidelines has been given lordship. So every financial bank ought to have been done by the procedural lordship, which was formulated by the Reserve Bank of India.
And I don't
As well
know.
as
I
the
don't know.
Honorable Apex Court is very much clear that lordship is not to.
Give me the judgment.
You have a duty bound to repay the outstanding amount to the bank authority.
Why are you not paying?
I'll pay.
How much will you deposit here? How much will you deposit here? How much do you owe? How much do you owe?
Almost lordship, according to my knowledge, lordship, 2 lakhs has been
2
remaining
lakh.
pending, 2 lakhs.
2 lakhs.
Yes.
How much are you supposed to pay as on today?
On to the lordship.
How much? What is it? Huh?
75,000 to 1 lakh lordship, I will pay it all. As on to the
Huh?
75,000 to 1 lakh rupees, I will try to pay. 75,000.
Which para?
In my petition lordship, I have not mentioned here.
Where? There's nothing here. There's no violence, nothing. Where is the higher purchase agreement? Where is the higher purchase agreement here? This judgment says that they can repossess the vehicle.
But yes, absolutely right. They have a right to repossess the vehicle, but procedure ought to have been followed. Lordship.
No, what
procedure
is
has
it? So that is, let us see the procedure. Where is the higher purchase agreement? Where is it?
been- Agreement is not effective.
Please bring it. You have got no right as on
Agreement
date.
is not available.
No case, Mr. Councillor, as on date.
So Lordship, call for
This
the
is your
status
judgment. I'm
report.
not,
For the status report.
no, I'm not going to
Now
call
the
for any
status
status report. I'm either going to dismiss your writ petition or I'll keep it pending till next year. We are awaiting a higher purchase agreement. And then we will see where is the clause for repossession. If it's there, then your case goes.
So Lordship, call for the
You bring it. I'm not going to call for it. You bring it.
try to bring it.
You have to.
Other hand, Lordship.
Right.
2008
The petitioner's grievance is with regard to the repossession of his vehicle, which has been hypothecated with respondent number
Mohinda and Mohinda, respondent number. Respondent number,
7.
yes, sir.
7 or 6?
6 and 7, boss.
6 and 7. The petitioner is aggrieved with the repossession of his vehicle, stating that though he has defaulted in the payment of the loan amount, he has already paid some amount of the loan amount. Full stop. Next para. A perusal of the judgment of the Supreme Court in MS Magma FinCorp Limited versus Rajesh Kumar Tiwari. AIR 2020 SC 4978. goes to show that if the hirer commits breaches of the conditions of a hire purchase agreement, which expressly provides for immediate repossession of a vehicle without further notice to the hirer, in case of default in payment of hire charges and / or higher installments, repossession would not be vitiated for want of notice. Full stop. In the present case, it is an admitted fact that the petitioner has defaulted in the repayment of his loan. Full stop. The only thing that has to be seen is whether the hire purchase agreement executed by the petitioner and the respondents number 6 and 7 provides for repossession of a vehicle in the case of default of a loan. Accordingly, now as the petitioner has not annexed a copy of the hire purchase agreement, the petitioner is given time, one chance to produce the said hire purchase agreement by the next date. Accordingly, leave this matter on when?
Lordship, first week of January.
First week of January. You got it.
48.
May I please, your lordship?
Yes.
There was a tender lordship placed by the respondent authority lordship. Petitioner and private respondent both participated and both the bids were admitted lordship, but I am the lowest bidder lordship. But I have given the tender to the highest bidder lordship. The last page of my petition lordship. 46 lordship. Private respondent, the quotation is there lordship. Private respondent, the first one, and page number.
Page 46 is the private respondent.
First one lordship, MD Mustafa. First name lordship.
First name?
I mean first.
Yes.
Yes.
MD Mustafa, yes.
Page number 45 lordship. My quotation is there lordship.
Yes.
I quoted lowest lordship.
How much?
Is there.
2 crores.
No lordship. My offered bid lordship. Column lordship,
We are talking about beef or what?
Yes.
rate offered by lordship.
Beef with bones,
Three, all the categories lordship.
all the categories. You are lower.
I'm the lowest lordship. But they have given the bid tender to the private respondent lordship. This is the.
What is your name?
My name is Shahidul lordship, Shahidul Rahman, petitioner. There are 3 categories lordship. Supply of food to the zoo captives.
Yes, what to do?
Lordship, first at page 14, your lordship. You find the page 14, your lordship.
Yes,
Down below point number 7, your lordship.
yes.
Bidder who seeks an appeal against any decision, action, or omission regarding the particular procurement due as per section 30 of the Assam Permit so and so. So now the petitioner is contending that this tender has been given to private respondent. If he's so aggrieved, there are appellate authorities to go to your lordship. In a writ petition, they have stated they have approached the authority, but I don't find any document stating that they approached the authority, your lordship.
The appellate authority, they have approached the concerned lordship, the concerned department lordship, concerned officer lordship. That statement I have given. The appellate authority I have not lodged.
So you approach.
They should approach it.
This is page 14 is here. There's a procedure for it.
First appellate authority is there, second appellate authority is there.
You go there.
Lordship. In that case, I will file. In the meantime, lordship, some protection, lordship.
What protection can I give? What protection? That you should be allowed to supply.
No, not that much, lordship.
Or they should not be allowed to supply and let the animals in the zoo die of starvation. What?
But some liberty may be given to us to approach the appellate authority because time is running, lordship. They will start. Then the
So what? They will start. Animals have to eat.
That is their lordship.
If they don't start, then the animals will die.
That too is for the
Then
states.
there'll be, even you will not be able to supply if they all die.
Lordship.
Everyone will be at a loss. Yeah, it'll be like operation successful, patient dead.
No, Lordship, but it is clear that illegalities is there, Lordship.
I don't know. That to let them decide.
Let them first
So you
decide.
withdraw, you go there. Okay, right. Miss.
Lordship, this matter now on fifth.
No, I'm disposing it out now. No point. Heard Ms. S. Kaningo, learned counsel for the petitioner, who submits that the petitioner participated in the notice inviting bid dated 2/11/2024 for supply of ration feed materials under group -F bracket beef for zoo animals under the Assam State Zoo for a period of 1 year. Full stop. The grievance of the petitioner is that though the rates of the petitioner was lower than the rates submitted by the respondent number 4, comma, the respondent number 4 has been selected as the successful tenderer. Full stop. Mr. R.R. Gugoi, appearing for the Forest Department, submits that in terms of the notice inviting bid dated 2/11/2024, clause 7 provides an efficacious alternative remedy to the petition when the petitioner is aggrieved, when a bidder is aggrieved with the
Decision.
action undertaken by the respondents pursuant to the NIB dated 2/11/2020. Next paragraph. Then you withdraw or do I dismiss?
I will withdraw.
And next, in Ms. S. Kanungo submits that in view of the submission made by the Council for the Forest Department and keeping in view clause 7 of the NIB dated 2/11/2024, the petitioner will approach the first appellate authority. She accordingly prays that the petitioner may be allowed to withdraw the writ petition, with liberty to approach the appropriate appellate authority. The prayer of the petitioner's counsel is allowed. The writ petition is dismissed as withdrawn. What?
Closed, Lordship.
Is closed as withdrawn, with liberty being provided to the petitioner to approach the appellate authority
Okay.
in terms of clause 7 of the NIB dated 2/11/2020.
Obliged, Lordship.
Make clear so also, my lord. Here also, my lord, petitions deposited, my lord, 1 lakh each.
Similar as item number 4, Lordship.
As like 4.
Okay, but this one out is on license, it's not off.
My lord, this is off.
Off.
Because initially it was on.
Okay.
Thereafter, as per the
Off,
government
off.
petition.
So all of them are off.
Off.
So all same order.
Same.
Out here except name will be Mr. B.K. Das.
And the respondent will
Sorry.
be different.
I'll appeal for the excise department, Lordship.
Excess.
Okay.
Okay, well,
Okay, then you write Mr. After issue notice, na?
Yes.
Mr. R. Gogai accepts notice on behalf of the excise department, while Mr. G. Bokalel accepts notice on behalf of the district commissioner. District commissioner.
Deputy Commissioner.
District commissioner.
Pendency shall not be above.
Same thing, pendency.
Obliged. All three are same, my lord.
All three are same.
Obliged.
Mr.
A.N. Sharma, my lord.
A. Sharma, learned counsel for the petitioner, prays that in para 3, okay, 1 and 2. This 1 and 2, Samindra so be implemented as respondents number 2 and 3. The prayers allowed, so are implemented as respondent number 2 and 3. Petitioner applicant to submit the corrected cost title to the registry within 3 days. The IA is accordingly allowed and disposed of. Okay. Then in the main contempt, you write, in view of the order dated 18/12/2024, passed in IAC 3886 of 2024, so and so have been implemented as respondents number 2 and 3. Issue notice to the newly implemented respondents number 2 and 3. Petitioner to take steps for service of notice upon the respondent number 2 and 3 by register post with AD within 3 days. List the matter after 4 weeks. Huh? The same in all the others, except the IA numbers will be different. Then. Same, all of the same persons. Yes. Oblige.
13 for everything.
Okay, Your Lordship. So I'm appearing for the respondent bank. The last occasion, I submitted that the respondent bank, which was originally implemented in the writ petition, is merged with the Punjab National Bank. So therefore, there is a requirement of impleting the subsequent entity, which is Punjab National Bank, but nevertheless, the affidavit which we had filed in the year 2019 itself has not been controverted.
Correct. Para 7 and 9.
Para 7 and 9.
Oh, they're not here. What to do? Mr. MP Sharma was supposed to be.
Last occasion, they had taken adjournment without informing me. Today, they are not present.
Okay, right. No one appears for the petition on call. Mr.
As the
S. Datta appearing for
private respondents, all the respondents. 2, 3, and 4.
appearing for response number 2, 3, and 4. Submits that the writ petition has become infructuous in view of the contents of para 7 and 9 of the affidavit in a position filed by the respondents number 2, 3, and 4,
2, 3, and
not being controverted by the petitioner.
Moreover, the loan account in respect of the loan which the petitioner had taken, that was closed in 2021 itself.
Further, the loan, our loan account which the petitioner was operating for taking the loan,
Education
for education loan, has been closed on,
was closed
had
on
been closed on
2nd August 2021.
2nd August 2021.
The certified copy of the bank statement needs to be kept on the record.
In this respect, he has submitted the bank statement issued by the Punjab National Bank dated 17th Feb 2024. The same is made a part of the record and marked as an exchange. It is also noticed that in the last order, Mr. MP Sharma, learned counsel for the petitioner, had prayed for and was granted 2 weeks' time to file affidavit in reply. Next. In view of the absence of Mr. MP Sharma, the matter is adjourned in the interest of justice. One time let us adjourn it. He's not here.
If he comes, it may be taken up after.
If he comes, you will just, if he doesn't come. So, list the matter in that first week. If he comes, you call him. Okay. We'll change it. If you can bring him, we'll change it.
Definitely.
Item 14.
Lordship, we are going to file affidavit today, Your Lordship. So matter will be taken up on after vacation, Your Lordship, along
Okay,
with
Miss RM Deka,
the.
Learned counsel for the respondent number for the Water Resource Department submit that affidavit is going to be filed today. Accordingly, release this matter after the vacation.
Item 15.
Last occasion, the PWD department was stated to file their affidavit. But late, they have not filed affidavit.
Is it infructuous? Because the work.
My lord, in fact, my lord, I did not challenge the NIT party in the what happened in this case, my lord. The government had sanctioned, my lord, 70 lakhs is against ordinary repairing and 1 crore 22 lakh 70,000.
Look, now there,
Yes.
you see, there is no question. You are asking for a fresh NIT.
Yes, my lord.
Now these are,
We don't know, my lord, whether that NIT has been called or not, my lord.
No,
Whether
no.
that work has been issued or not, my lord.
who is for the PWD?
Earlier, Mr. Gogoi was appearing, my lord.
Can you call them? Can you call the PWD council? After some time.
Or maybe first week of January.
No, wait. We
Well,
have to,
well.
we cannot keep it pending.
18 and 19.
Yes,
Lordship, see a proposal is under process, Lordship, 10 days more time will be required, Lordship.
okay, Miss
Zero.
G. Bora, Learn Council for the Agriculture Department. Pays for some more time. As the proposal is pending approval of the Honorable CM.
Lordship.
Approval not given.
Approval is not, is in the under process, Lordship, in the department, Lordship, we shortly submitted to the CM
Okay.
for its approval.
Okay. Please this matter after the vacation. Huh?
May I make my request, my lord? In item number 31 of today's list, my lord.
31?
31 of today's list, my lord, pertains to the same subject matter, my lord. So, my lord, on the last occasion, my learned friend had submitted that Assam Seed Corporation was a party and they also need to submit an affidavit, my lord. So today, till date, they haven't filed any affidavit.
Did your turn come,
Yes,
Mr. Council?
Item 20.
No one appears for the parties. List the matter after the vacation.
Item 22.
Please, Your Lordship, it is PWD department, Your Lordship. Lordship, the admitted liability of security amount to be
You have completed the contract.
completed, already advised to pay the security amount by the NHR two, but they have not, it is 2020, they have not paid it.
You
I-
completed the contract when?
Yeah, and it is already completed. It was completed in 1/11/17. And payment advice was given on 13/8/24 NHR two.
Okay, we'll call them to appear.
Yeah, Lord.
They're not coming. No one, the PWD also is not coming, right? Mister?
What's the BK General?
Huh?
BKJ.
BKJ Learned Counsel for the petitioner. The petitioner's counsel submits that the contract work that had been allotted to the petitioner had been completed on
1/11/17.
26/12/15.
No, it was 1/11/17. Your
Acha,
Lordship.
when was it completed?
It is page 14, Your Lordship.
Which date?
Your Lordship, it is 1/11/17.
1/11/17. Good stuff. However, despite the same, the security deposit of the petitioner has not been returned to him. Which amounts to rupees
Amount rupees, Your Lordship, 4,94,894.
4,94,894. Good stuff. It is surprising to note that despite a lapse of more than 7 years,
And
the security deposit has not been given back by the PWD to the petitioner.
it will be paid by the respondent number 5.
Acha, by the respondent number 5. Who is he?
That is Bibro College.
Huh?
Because it was a government grant for construction, but the grant was given to the college and work was done through PWD. Amount is to, security amount was cut by the college. Respondent number 5. And
By the respondent number 5.
That's what 5, no?
I am first from the five losses.
Yes, madam.
My lord, I'm
Seven.
ready to pay this
Then,
bill amount. Only this have certain problem are there in electric fitting fan and my lord, switch, etc. That maybe rectify and take the bill.
madam, he completed the work in 2017.
Yes.
Naturally, after 7 years, these problems will arise.
No, not now. My lord. At that relevant point of time, the problem arose. And he was verbally requested to rectify those things. But instead of he
Ability period already over and they were advised to pay, make payment in 2020, Annex 2, page 40. Liability period expired long back. Then उसमें kindly third paragraph in the.
Okay, next, you're right.
This one?
Annexure 2 of the writ petition. Pertains to letter number AC/52/Roman 3/PT dash Roman 5/9407 dated 18/9/2022 2020. Issued by the Executive Engineer PWD, Guwahati Building Division 1 to the Principal B. Borwa College, Ulubari,
Paragraph second law.
which states that there is no liability against the work completed by the petitioner and as such, the security deposit deducted from the bill at source should be released. Next para. On considering, next para. Yes, so this letter is there, madam.
Yes.
You have to,
We'll pay money.
you have to pay. Acha, in the beginning, you write Mrs. So and Miss
P. Burman.
P. Burman appears for the respondent number 5. Huh? Yes. In view of the stand taken by the PWD, Government of Assam, that there is no liability against the work completed by the petitioner, and that the security money was to be released to him as per the letter dated 18/9/2020.
Detail on page 16.
The details and in terms of the details of the security deposit money. That's all. No, don't say it in terms of the respondent number 5 will have to pay the security deposit amount of rupees 4,94,894 as detailed by the Executive Engineer PWD, Guwahati Building Division 1. So accordingly, the respondent, the principal of the respondent number 5, the principal, accordingly, the respondent number 5 shall pay to the petitioner the security deposit amount of rupees 12 within 2 weeks from the date of receipt of a certified copy of the file. This is his money, not your money, madam.
At least 4 weeks. Madam.
3 weeks. The writ petition is accordingly allowed.
Much obliged.
Affidavit filed today, my lord.
Item number 23 and
cases, ma'am.
27, they are similar matters, Lordship.
Affidavit filed in 23, my lord, today, and earlier 27 had to file long 4 days back, my lord. Both be taken today and fixed on after vacation.
It is for dues.
It is for dues.
Have you admitted?
No, they are challenging it. One case they are challenging, they have not admitted, my lord. They have been ejected, my lord. By the committee constituted. for-
Okay, right, Mr. S. Bora, Mayor Council for the GMC submits that affidavit has been filed today.
That's it.
Accordingly, this matter after the vacation. You want to file any reply?
We'll go to the affidavit.
Miss
K. Bharali.
came orally appearing for the petitioner may submit affidavit in reply in the meantime.
2020.
If required.
27.
Same party, same minus.
No, but he has not filed affidavit.
Every fail.
You filed. Okay, same order in item 27 also.
24. Already infectious, my lord. Because the work has been allotted to someone else. He is against that order.
Yeah,
Setting that, my lord, he has lowered it and it is against public interest.
My lord, given is that also, my lord, but another given is that, my lord, his earnest money, my lord, that was forfeited, my lord.
Okay,
During
that will be, my lord. In
during
fact, there
the-
is a series of cases where lordship has dismissed the cases, my lord, of this petition. Relating to the same case. Well, instead of giving my lord additional performance security, he came to challenge that particular decision of ours.
Okay, he gave to challenge and he carried on challenging it.
He carried on challenging, my lord.
Now he wants to pay.
No, now he offered that, my lord, but
Ah.
we my lord declined, my lord.
Okay, I did.
Yes. And now, my lord, whatever work we have allotted to a third party after this, my lord, cancellation of his bid, that now he has challenged in the present litigation. And
Okay.
since he could not perform the
Earlier he was allotted the work,
work- Yes,
but he did not want to deposit the
additional performance security.
additional performance.
Yeah.
So that he lost.
He
the-
lost
the-
even before the division bench.
He lost before the division. Now he wants to
No,
proceed with the
he
work.
then proposed that he will make my lord payment of that particular additional performance.
And then he should be
Then
given
we
the work.
rejected that particular prayer.
Ah.
As per my lord court's direction, we considered we
Miss the
rejected.
bus.
Now.
Too greedy, miss the bus.
Now, my lord, the earnest money, my lord, that was forfeited, my lord.
Okay, well, we failed to-
That earnest money was, my lord. That speaking order was passed, my lord, during the continuation of
Naturally.
interim order, my lord.
Naturally,
My lord, tell time.
you were given you were asked to eat chole bhatura. Now you are going to get sukha roti only.
Now, my lord, just for, kindly come to page 76, my lord. This is the speaking order, my lord.
Huh?
Page 76, man. This is an speaking order, my lord. Last paragraph, my lord. Point 2, my lord. Last.
Yeah.
On the failure of the bidder to submit performance security and additional performance security, the bidder's bid security was forfeited on 28/2/2023 as per the provision of the clause 30 of the instruction of bidders, section 2 of bidding document.
So,
Now,
what is
my-
wrong?
kindly note the date, 28/2/2023.
Huh?
His date, my lord, 28/2/2023, my lord, his bid security was forfeited, my lord. Now, my lord, kindly come to page, my lord,
No, we are at page 76, correct?
my lord.
Ah.
That it is stated that his bid security was forfeited on 28/2/2023, my lord. Now, my lord, this was done, my lord, during the continuation of an interim order of this court, my lord. That is the thing.
That you go and file contempt.
On them, yes.
You go file contempt.
And the proceeding has been.
That is the
dismissed by-
different procedure. You file a contempt, Mr. Counsel, this I cannot go into. Well, that is a different issue. This is not a contempt proceeding. You go file a contempt.
In fact, my lord, through my knowledge, my lord, inadvertently they have done it. But I informed the honorable court and during the proceeding that inadvertently we have done, we will not execute it till the, my lord, final disposal of the petition. It was dismissed, my lord, accordingly it was upheld, my lord. It was dismissed, my lord. And it was within the knowledge of the counsel who appeared at that point of time. Senior counsel can certainly appeared, my lord, in those cases. That's not the issue here, my lord.
It is the petitioner in person.
Now he has started appearing in person. Now, my lord, he is the new counsel.
Okay, new counsel.
New
Now,
counsel.
my lord, new.
Anyway,
Yes, otherwise he has the right to appear. He has appeared now. He is
Yes,
the
yeah.
counsel.
there
But,
are
my lord, the issue is that-
some persons who like to go to court, I think.
Yes. In fact, my lord, he is not the first, but the second highest, my lord, contractor who is, my lord, filing cases after cases. before the
Now, my lord,
honorable
what
court.
happened, my lord? He said, then these things are going on, my lord. Whatever, my lord, petitioner had offered lawyer bid, my lord. Definitely, my lord, 17 or 19 was bid, my lord. Now, my lord, that work subsequently had awarded to the contractor, my lord, who had offered more than 10%.
What to do? Because of your because of your delaying tactic, the price of materials go up also. You know the cost index.
10%
You see the SOR rates. You see, you see the CPWD manual, how fast the cost index goes up.
But 10%
How fast?
more than 10% above, my lord.
Yeah.
It also
So
costs,
much.
my lord.
Within a year, this cost goes up. What to do? Like I said, you should have been happy with what you got. You
I like to withdraw, my lord.
You will withdraw, my lord.
withdrawing.
That's okay.
Okay, Mr. N. Hawk, S. Hawk,
Yes, sir.
learned counsel for the petitioner, submits that he may be allowed to withdraw the writ petition. Mr. B. Gogoi appears for the PWD. And Mr. S. Data appears for
Now everybody.
respondents number 4 and 5. 4 and 5. The petition, pair of the petition's counsel is allowed, writ petition dismissed as withdrawn. Acha, ek hi rata.
My lord, 26 is similar.
26 also withdrawn.
With, my lord, can you liberty?
Okay, with liberty to file a fresh.
My
He will come again.
That is the danger, but then he'll account it.
Not on the same ground, my lord.
I can understand if it was you, but he comes himself also.
Yes, my lord.
He comes by himself. And let him do it. Let him.
yes.
But lordship may indicate not on the same ground.
No,
That
there
is
is
not
no
on the
but.
same ground.
No.
He trial and he'll come up with again.
It's okay.
My lord,
We-
26.
20,
26.
26 also same order.
15 was there. 15 is there. I don't know 15. Oh, okay.
No, which item is this one? 25.
So, my lord, item 26 is similar. He has withdrawn 26 also.
26 also same order.
I don't know 15 was there.
So you want 15?
Yes.
Oh, give me 15. Yes, Mr. Bobai.
My lord, lordship will post it after vacation. My lord. I will have the admissible report, my lord. It's about 101 crore or something, my lord.
Is this the case where the work was allotted without NIT?
Yes. Without allotting an NIT.
Well, let me have the instruction, my lord. Sorry, my lord.
So, no, the only thing is, you see, the problem is,
Sure.
now, this, what is the stage?
Lordship.
Because this case was last listed in June 23.
Sure.
June 23.
My lord.
So, because it has been probably allotted
To someone
to someone, if so, what is the status?
that
Has the work been completed? Has it been started? Has work order been issued? Something. Okay.
my lord.
Mr. The petitioner's case is that the work has been allotted without issuance of a tender. So, Mr. B. Gogoi shall obtain instructions with regard to whether the work in question has started and the
For any
percentage of the work done.
For any NIT was it.
Huh?
For any NIT was it. Because that.
For the work done. First off, this is the matter. In the after the vacation.
I'm obliged.
Obliged, my lord.
25. Yes. It's okay, sir.
25. May please, lordship.
Yes.
Also, in this matter, my affidavit is pending, Lord.
Final.
Yeah, finance, no, it's BTC, Lordship. It's instruction awaited, Lordship.
Okay. So, Mr. P. Nayak, learned counsel for the
BTC.
BTC is granted
Possibly granted 4 weeks, Lord.
4 weeks time to file affidavit. This is the matter after 4 weeks.
Interim is there, my lord.
Interim order to continue till the next day.
Obliged. Item 28.
Please, your lordship.
That will be my matter pertains to non-payment of contractual bill.
Contractual redress.
After vacation, my lord, I will have to. Part
Sure.
payment is to be made, my lord.
Lordship, second round of litigation, lordship, page 25. There is already an order of this honorable court, lordship. Page 25, your lordship.
No, you wait. Mr. B. Gogoi is granted 3 weeks time to obtain instructions and file affidavit if necessary. This is the matter of the thing.
Deeply applicable.
29.
No affidavit.
Non-religion of.
Vehicle high charges, I know.
BTC is there.
BTC. Earlier it was Mr. Rabha. S.R. Rabha was there.
Has been allocated to SR Ravala. Let me appear on his behalf.
Okay, right. The BTC council is granted 3 weeks time to file affidavit. This is the matter of the 3 weeks.
31.
Yes.
My lord, pertains to the non-payment of contractual.
For the city, and if any for the city corporation, my lord, we not for the instructions, my lord, instructions are awaited.
Mr.
A.N. Sharma,
A. Sharma. Council for the respondent number
4 and 5, my lord.
4 and 5. And Miss G. Bora for
Say 1, 2, and 3, lordship.
1, 2, and 3 are granted 3 weeks time to file that affidavit.
Obliged, my lord.
This is the matter of 3 weeks.
22.
Then morning I filed one additional affidavit law that is not in record, but I have given one copy law.
Well, as per your lordship's order, my lord, I am annexing all these documents. My lord.
These are two amendments which were,
Huh?
these were the two amendments which were carried out to the Society Registration Act by the Government of Assam. Those will be pertinent for the.
Yes, Lord. So one additional has been filed today morning, Lord.
Additional affidavit.
Yes, Lord. I have furnished copies. It is not in record, Lord. So I have given.
Oh, it's not on record.
Loose copy.
You give me what?
Lord, sir.
Affidavit has been filed today.
Additional affidavit.
It's not here.
Lord, sir, one extra copy has been given.
Have we do any note in this case? We have not made any notes in this case, no? Did I dictate anything earlier? No.
No, Lordship, only instructed me to file one additional affidavit.
Lordship, the question as regards the existence was to be determined today by the documents.
Existence of the
3 years as an NGO. That was the, as with the bid requirement, Lordship. They have stated they are earlier registered, but registration failed and they have re-registered.
What is this?
Oh, sorry.
This is your document, I think.
Is your note.
Oh, that is my note. No, that is my note, my lord. Sorry, it is good.
Let me see if you have hidden anything.
Lordship, yes.
Huh? Something not good for you might be here. Huh?
Yeah, I have also seen that note, Lord, with how it got left and when it was Because of COVID reason. COVID period, Lordship, he was unable to renew. He filed application, but it was not renewed during that period. Subsequently, it was renewed. But as per the provisions, Lordship, it got left, and that is why he has been given a new number. But the society-
And it was in existence since 2012, my lord.
Left.
The real.
Lordship, I have filed one additional affidavit, Lordship, and kindly tell me that, Lordship. Yes. Paragraph 3, Lordship. Lordship, as per 4.2 of ITB 36.2, Lordship, the requirement was bidder must be a legal entity in existence for more than 3 years. Lordship, first submission data, it has not been mentioned that it has to be a continuous 4 year, a continuous 3 year. Existence, he should have more than 3 years existence. And in our evaluation, it was found that his existence started from the year 2011-12 itself. So up to 2017, there is no problem, Lordship. 2017 to 2021, it lapsed. That's my kindly say page 3, Lordship.
So when did your entity come into existence? The new one with the new number? When did your entity come into
One
existence?
certificate has been given, Lordship. It was registered in October 2021.
Huh?
October 2021.
And the last certificate is also. I marked.
October 2021.
Yes. But if Lordship goes by the affidavit, Lordship may kindly say page 3, small Roman 2, Lordship.
And when was the NIT issued?
In July 2024, and last date was submission was August 30, 2024.
So he did not have 3 years.
An effect of non-renewal is the striking of the name from the register, Lordship. That is by the Amendment Act, very Assam. Lordship takes the amendment of 2019.
Just a minute,
Lordship,
just
kindly
let me.
come to page 3, Lordship.
Yes.
B, small b, the bidder must be a legal entity in existence for more than 3 years. In this regard, it is the submission of the deponent that the bid was open for any legal entity and it was not limited to NGO societies only. The same was clearly defined in the bidding document and was reiterated in the pre-bid meeting. As per internal official record and also certificates attached in the bid, it was confirmed that respondent number 3 society is operational and providing service to the government since 2014. To prove its legal existence, the bidder had submitted more than adequate documents such as work orders, LOAs, employers, government department certificate issued in 2013, 14, 17, 19, 2020, and also 2024. The certificates are genuine and verified and prove that the bidder is a legal entity and executed assignments and in existence for more than 3 years. Submitted PAN in the name of the society, submitted society registration certificate. In addition to the above, PAN card, it is some mistakes is there, Lordship. That 77 is actually his date of birth, Lordship.
His date of birth.
That is not issued in the year 1977. Then if Lordship comes to the next page, Lordship, also possess the society registration certificate with effect from 2011 to 2014. And the society registration with effect from 2014 to 14. As per Rule 23, Sub-Rule 15 of APR, Assam Public Procurement Rules, Lordship 2020, historical documents may be considered while evaluating the bids. In this regard, it is further submitted that the allegations made in the writ petition are baseless as the same are raised by a bidder who himself was found to be non-responsive. Moreover, the bidding document and all its text, including provisions of immaterial deviations, are notified bidding documents contained under the provisions of the Act and the rules. Most important, there is an inherent appeal provision, and the petitioner has approached the Honorable Court without even exhausting the said appeal provision of appeal procedures as per clause 7 of section 1 of the bidding document, intentionally to delay the process and impact the health and hygiene scenario of the city. Considering the above facts, and the bid evaluation committee found that the respondent number 3 society is a legal entity in existence for more than 3 years by all means. In this regard, it is also to be noted that nothing in the text of the bidding document states the years of specific requirement, and rejection is not allowed as per section 4, and also as per the Assam Public Procurement Act 2017 and rules of 2020. It is pertinent to mention that the matter relates to garbage collection and sludge survection, and delay caused by the petitioner is expected to impact the spring of the Guwahati city in sludge survection. So that is our submission, Lordship. But basically, the authority considered all the documents available before it, including the historical document, and arrived at a conclusion that the society is a legal entity for last more than having its existence for more than 3 years. That is the basic satisfaction, Lordship. Lordship, it comes to page 49 note of the writ petition. Page 49, Lordship, it's 30.2, Lordship. A bid shall be deemed to be substantially responsive if it meets the requirements of the bidding documents without any material deviation. Lordship, that word material deviation has been defined at 30.3 down, Lordship. Material deviation, reservation, or omission is one that, if accepted, shall affect in any substantial way the scope, quality, or performance of the subject matter of procurement specified in the bidding document, or limit in any substantial way inconsistent with the bidding documents the right of the employer or obligation of the bidder under the proposed contract, or B, if rectified, shall unfairly affect the competitive bid process of the bidders possessing responsive bids. I'm not at B, I'm concerned with A, Lords. So no such material deviation was found to declare the private respondent substantially responsible. So that was the point, Lordship.
No, you said that he is not responsive. Why is he not responsive? His bid?
That has not been explained. This statement has been made, Lordship. That I have to hear. But otherwise also, Lordship, he is at serial number 4, Lordship. Even if the petition is allowed, Lordship, he will not get any benefit. So no right of the petitioner has been violated or affected, Lordship.
He has not challenged, he has not put to challenge the others.
He's
Other parties there.
No, Lordship,
Those
only
two
thing
and
we are-
three?
we're pointing out the evaluation process was not as per law. So the Honorable Court should intervene and make them do it as per law, Lordship. Bid document was flouted, the norms were flouted. That was brought before this court. This question was also on the day when the matter was first listed, Lordship. Lordship was hard on that point. Lordship was satisfied. It is not necessary that we need to wait. It has to be as per the law and not arbitrary. And that on that basis, the winning is not the case, Lordship. It has to be done as per the law, which has not been done by the GFC authority.
Lordship, one judgment, Lordship, I would like to place, Lordship. I have
Lordship,
already furnished copy.
Before you go to judgment, Lordship, may I please, Lordship, point out how it is registration and renewal are different aspects, Lordship. The registration has to be a new entity which comes into existence. And failure to renew by the Amendment Act of Government of Assam says, Lordship takes Amendment Act 2019. 2019.
Yes.
Lordship, come to third page. Page number, third page, Lordship.
Third page.
Last
Yes.
point, 3D. That is Amendment 3, Section 3, Amendment 6 was 3D. Effect of failure to renew registration.
Yes, sir,
3D, the last one. Amendment of 2019, Lordship.
3B.
D.
D.
Last
D.
one.
Yes.
Effect of failure to renew registration. A society which fails to get its certificate registration renewed in accordance to Section 3C. Its registration lapses and itself ceases cease to be in a registered society with effect from the actual date of expiration of its original registration or renewal thereof, and its name and other particulars shall be struck off from the register in which it was earlier registered or renewed, provided that no such registration shall be struck off before the expiry of 12 months from the date of expiry of the validity of the previous registration. For this purpose of calculation, that is the calculation. So their name was struck off. Another point, Lordship, in 1967, there is amendment to the same act by the government of Assam, which is same name cannot be existent for two NGOs or societies, Lordship. That is part of the, if Lordship takes up, I've given a copy.
No, that is not the issue here.
Lordship, the question is there, Lordship, they had a name is Orion, which was lapsed. They again registered with the same name. That cannot be, that is not permissible as per the law of the government of Assam.
Lordship, he has not placed the amendment of the 22.
I
22 is most.
I do have the
22, Lordship.
I do have the copy.
22 has a specific provision for those.
They can renew.
Whose registration got lapsed because of the provision of 2019. And that provision was subsequently amended, Lordship.
Yes,
Now, the societies whose registration got lapsed can also register their name or renew their name, Lordship.
They can renew,
Be
not
it a
register.
new number, Lordship, or earlier number. Earlier number
They can
doesn't
renew.
matter, Lordship. Society is the
They can, they can.
Renew,
the same.
not register. If in 2019 amendment, the time period for failure of registration or applying for registration after the lapse was 1 year, which is substituted in 2020 to say more than 1 year. So anyone whose registration has failed for more than 1 year can also apply with a condonation application, which the registrar will consider. That was not done. They have registered fresh. Fresh registered a new entity, and Lordship will kindly take up. I've given a copy which is from the website how to register. This first page is government. Yes, Lordship. Lordship will come to next page. Second paragraph. As per section 3A of Societies Registration Act, no society shall be registered under a name which is identical with Orion Society was in existence, they have lapsed, or too nearly resembles the name of any other society or any body corporate which has been previously registered or incorporated under this act or any other law for time being in force, as is the case may be. So they could not have registered the same name. They have done it with flouting any other norms which we are not aware of, Lord. That could not, that amendment was of 1967, Lord. They cannot have the same name for the new registration. That is also been carried out for.
Anyway, it has been done. You have not put a challenge to that.
No, Lordship, we are only pointing out is the bid, what is the requirement of the bid document was followed. The GMC author is coming up with explanation for the respondent number 3. But where have they got this? They have not asked for by asking it. They have not issued a letter asking them to explain. Now they're coming subsequently. At the time of evaluation, that was not considered. They have flouted the norms because there's nothing on record to show they have gone to respondent number 3 asking for explanation on those points. So now they cannot do after they have evaluated. They have to re-evaluate as per the.
How he is affected, even if somehow.
It's not my effect. The society itself is affected if they're not.
How he is affected, Lord?
They cannot be
It's a
arbitrary.
repetition, Lord. It's not a PIL. How he is
I'm not on PIL. I'm only on with this tender, this package, Lord. Let them re-evaluate. We have no grievance if they re-evaluate on the basis of the tender. Then tender conditions we are satisfied. Let them re-evaluate as it has to be done as per law, as per the tender document. We have no grievance further than that. And they don't have a problem with re-evaluating. They do not consume time.
Reevaluate for what purpose?
But because they have flouted the norms, let them re-evaluate all the tenders with by
Except for the private respondent.
Lordship, all let them do it for all because they
Why?
even for
Then
respondent.
same decision.
Yes,
they
Lordship,
come to.
but they have flouted the norms for that not being in existence for 3 years. That is given in the bid, which they have flouted. And now if they come up, it is not material. In the affidavit they have filed, they have not taken that as an immaterial deviation. They have taken the financial part as an immaterial deviation, which we have not challenged. Let that be. But if someone has to go on a bidding process, if their existence itself is in question, that is material, Lordship. If I go and apply for something, my existence is in question, that is material. There cannot be immaterial deviation from the requirement which is supposed to be adhered by the GMC authority.
Basically, your prayer should be that the private respondent should not be should not be considered.
Lordship.
Because if they're not entitled, they're not entitled.
Lordship. And the process, all the 3 remaining will, whoever comes, we have no grievance, whoever wins that. Because he is not qualified to be bidding in this, at least in this bidding process.
So
And
you're,
if the retender-
so you're L4.
I'll be L4, Lord.
You're L4.
I'll not be winning it, but let not be illegality on that one. But they have gone flouting the norms. we came to know, I was participant, so I have a grievance which I have raised before this honorable court, and honorable court should intervene because they have been arbitrary. If there is a deviation, it has been arbitrary. And it has been held by honorable Supreme Court, when there is arbitrariness on the evaluation of bid process, honorable court should interfere. I have a judgment if lordship allows me to place it. The full bench of this honorable Supreme Court.
Full bench of Supreme Court.
Lordship,
What is the full bench of Supreme Court?
3 judges, Lord. Lordship, directly come to second last page. That is paragraph number 34 from below 6 line, Lordship. From of the first paragraph 34.
Yes.
The action of the first respondent in accepting this tender of the fourth respondent, even though they did not satisfy the prescribed condition of eligibility, was clearly discriminatory since it excluded other persons similarly situated from tendering for the contract, and it was also arbitrary and without reason. The acceptance of tender of fourth respondent was in the circumstances invalid as being violative of equality clause of constitution and also of the rule of administrative law inhibiting the arbitrary action. So if it is arbitrary, it should be interfered. Another subsequent bench also has said, if the action is arbitrary, honorable court should intervene. And if the deviation from the rule is arbitrary, that is what this judgment says, Lord. Rule as in whatever the bidding requirement that is supposed to be adhered. So they will not qualify, they are not in existence, and they cannot say they were in existing. It is admitted position 21.
Have you filed affidavit? You're not filing.
Because I relied on the affidavit filed by the.
Have we recorded that you are relying upon the affidavit of the private respondent, the government?
And some, I have been only the submission.
No, that's all right. You see, that's all right. You see, the only thing is that if you're going to take a stand that you're not going to file affidavit, it's okay. But I don't want you all to start arguing and then later say that I will file affidavit. Because the order can go either way, can go this way, can go this way. So that's why, because unless you have an affidavit, you might find it difficult to make out a case in appeal.
Okay.
So I want you to take a decision as to whether you are going to file an appeal, file a affidavit, or make a submission which will be recorded to the effect that you are going to rely upon the affidavit of the state government.
That's it, okay, my lord. I rely on that affidavit. Only my submission is that, my lord, regarding this is that the lapse because of the COVID reason, my lord, for the COVID.
They are not going to explain.
Even the government of India has exempted many relief money.
No, Mr. Counsel, whether this court can overlook the law. The question is, if the act provides a certain thing can be done only in a certain way, can we overlook that?
The amendment of 2022, Lordship.
Let us see that.
Once again, my submission remains, Lordship, page 59, Lordship. Lordship will once again see the eligibility criteria. He is repeatedly arguing that it has been violated, but I am submitting, Lordship, in what manner authority satisfied itself. Page 59, Lordship.
Yes.
Lordship, may kindly see the eligibility criteria.
Yeah.
To qualify, second paragraph, Lord. To qualify for award of the contract, bidder shall meet the following minimum qualifying criteria.
Correct.
Lordship, may kindly see first one is the bidder should have experience of projects pertaining to waste management or door-to-door solid waste collection continuously for the last 3 years or for any municipal corporation that is satisfied. B is the bone of contention, Lordship. The bidder must be a legal entity in existence for more than 3 years. Lordship, it starts from 2011.
The problem is registration number is different.
No, registration number, Lordship will say subsequently, but it has not been stated that his existence has to be continuously for 3 years prior to the.
No, so you are basically, supposing the name was changed, the persons looking after the entity was the same. Supposing instead of Orion, they have said some other name, say train or something like that.
No.
So
Lordship,
but the persons
Before-
behind it was the
before,
same, then
Lordship,
what will
he
it
has
be?
just now submitted in one name, two registrations cannot be there.
Correct.
Yes. So he has not challenged the decision of the authority.
No,
I applied
no,
authority
Mr.
granted me
Counsel,
registration.
Mr. It's like this. Supposing that car, supposing the car has got one registration number, and then after 20 years, it has been given another registration number, then what happens?
Lordship, it got lapsed, but because of the amendment of 2022, his registration was renewed. Lordship, may kindly see the 22 amendment. Lordship. He has-
That's what I'm saying. Let me see the
Lordship, was it
22
renewed?
amendment.
Lordship, will kindly take
Lordship,
note of
either
the
his
argument.
him
Was it
submit,
renewed?
Lordship, or let me submit. Lordship.
And he has submitted, it is renewed as per 2022 amendment. Is it renewed, Lordship? No, it is registered.
It
Still
is
there.
renewed. That is why same name, Lordship.
It is re-
Otherwise, it will not be
No, let us,
same name.
let us,
Lordship, amendment came in 2022 and they have registered in 2021 in the same.
21.
Name.
ah.
How can they get the benefit of 22 Act in 21, Lordship?
22 is not retrospective.
Lordship, that cannot be done. And also the amendment of 22 says, Lordship will kindly take up section 3C amendment, that is subsection 1. In subsection 2, in clause 1, the proviso in second line, the word for up to 1 year, which I've already submitted, that earlier it was 1 year, within 1 year, they cannot do so. Appearing in between the words of a society and expiration of the words for more than 1 year shall be substituted. So they are allowed to go for renewal by applying for condonation. But they are not,
And that period should be 1 year. No,
earlier it was 1 year as per
Oh.
2019. If that lapsed, they cannot go for renewal. But 22 said they can go even if more than 1 year with an explanation. Why? And that is discretion lies with the register to renew it or to reject it. They also have a provision for appeal if the rejection is done. They have not gone for that.
But anyway, 22 cannot be applied in 21.
No, here it is, the situation is different. The renewal was applied in the year during the COVID period, but it was not renewed because of the COVID period, Lordship.
But when okay.
Subsequently, when
So, no,
22
Mr.
came,
Counsel,
Lordship,
let us
yes,
be sure.
Lordship.
When was it renewed?
It was renewed in 21 because his
It
application
was renewed in
pending.
21 by using a 22 thing.
His application
How
was
can it
pending.
be?
Lordship,
How can it be?
Lordship, his application was pending
Maybe.
on the basis of 2022, Lordship.
But just think of your submission. You are going to apply
Lordship.
an act which is going to be published in the year 25.
Lordship, even if that
In the year now.
Lordship,
How did you do it? They have got
even
a
if that point is not praised, Lordship,
no.
to us, Lordship, society is the same. We given them letter of acceptance in the year 2014. We given them letter of acceptance in the 2017. Up to 2024, he continued. Same authority continued with us. Lordship, it is not necessary that to be a legal entity, he has to be a legal NGO or he has to possess a registration certificate. On the basis of having income tax return certificates, also one can be regarded as a legal entity.
Did he apply individually or with the name of NGO?
Let us see. Yes.
Lordship, I'm coming to that point, Lordship, but my submission will remain, Lordship. This 3 years period is not continuous period. Lordship, one judgment I have placed, Lordship. It is also full ban.
No. You see, this 3 years period, you see, there are many ways of looking at it. You see, with regard to even this grade 1,
It's a it's
grade 1,
interpretation.
just listen.
Yes, Lord.
Grade 1 of judicial service. Now, whether that 7 years as a lawyer is required to be continuous or not, those also you have to look at. They are Supreme Court judgments. Have you seen that?
Yeah, in that situation, Lordship, who should get the benefit of doubt, Lordship? If it is, I'm just submission on the other. Lordship, one judgment I have placed, Lordship, 2023 Live Law SC 467.
Page?
I have given copy. Lordship, may kindly come to paragraph 52, 53, and 54. Last 2 pages, Lord. 52 is basically for fresh tender, Lordship. I'm coming to that paragraph last, Lordship. 53, Lordship. The law relating to award of contract by the state and public sector corporations was reviewed in Air India Limited versus Cochin International Airport Limited, reporting so and so. And it was held that the award of contract, whether by a private party or by a state, is essentially a commercial transaction. It can choose its own method to arrive at a decision, and it is free to grant any relaxation for bona fide reasons if the tender conditions permit such a relaxation. I'm referring to that responsiveness, Lordship, material deviation. It was further held that the state its corporations, instrumentalities, and agencies have the public duty to be fair to all concerned. Even when some defect is found in the decision-making process, the court must exercise its discretionary powers under Article 226 with great caution and should exercise it only in furtherance of public interest and not merely on the making out of a legal point. The court should always keep the larger public interest in mind in order to decide whether its intervention is called for or not. Only when it comes to the conclusion that overwhelming public interest requires interference, the court should interfere. Paragraph 54, as observed by this court in Jagdish Mandal versus State of Odisha and others reported in so and so, that while invoking power of judicial review in matters as to tenders or award of contract, certain special features should be borne in mind that evaluation of tenders and awarding the contract are essentially commercial functions, and principles of equity and natural justice stay at a distance in such matters. If the decision relating to award of contract is bona fide and is in public interest, courts will not interfere by exercising powers of judicial review, even if a procedural aberration or error in assessment of or prejudice to a tenderer is made out. Power of judicial review will not be invoked to protect private interests at the cost of public interest or to decide contractual dispute. So these are my basic submission, Lordship. If Lordship comes to paragraph 52, Lordship, 52. Ordinarily, a writ court refrain itself from imposing its decision over the decision of the employer as to whether or not to accept the bid of a tenderer unless something very gross or culpable is pointed out. The court ordinarily should not interfere in matters relating to tender or contract to set at naught the entire tender process at the stage when the contract is well underway. Would not be public interest. Initiating a fresh tender process at this stage may consume a lot of time and also loss to the public exchequer to the tune of crores of rupees. The financial burden implications on the public exchequer that the state may have to meet with if the court directs issue of a fresh tender notice should be one of the guiding factors that the court should keep in mind. This is evident from a three-judges bench decision of the court and so and so. So these are my basic submissions, Lordship. All the other work orders has already been issued. This is the only, the section remain, Lordship. So right now we are doing the job, but it's not to the level of satisfaction. So that is why we need the service of the contractor who has been selected as the L1 bidder, Lord.
Where is that provision again, that tender? Page 59.
Eligibility criteria.
Eligibility criteria, page. Page 59.
Yes, sir.
That's all.
Lordship. These 3 years may be different, interpreted in different manner, Lordship. But to the understanding of the authority and to the interpretation of the authority, as he was continuing from 2014 itself, Lordship. So according to authority, same authority, entity is the same. Registration may be different, Lordship. But for the GMC authority, Lordship, as they are working for us since 2014, the same authority, same person, same society.
You were saying that the registration, if it's different number, it's a different entity.
It's a new registration.
Where is that?
But the act itself says the renewal, it fails, Lordship. The
Huh?
Act of amendment says if they do not renew it, the names are struck off, so they are not in existence.
Where is that again?
19 amendment, Lordship, 2019 amendment.
19 amendment, yes.
Amendment to TC, Lordship. Third page, 3D, Lordship. Kindly take note of 22 amendment, which
22.
22, which says they are permitted to go for renewal application, to which they have not done. They had the option of going for renewal application, to which they have not done also, because it permitted them to apply for renewal in 2022 by the amendment, which they have not done. They have stuck to the new registration with the same name, which is also not permissible. That probably they have overlooked it. And also another point, why the intervention of this honorable court is required is because in a similar repetition on the other day, Lordship has passed an order to adhering them to 300% of the final. If the bids are abnormally low, they should be made to pay additional security of 300%, which they have not done. Now they have done it after honorable court has passed an order. So that's why the requirement of intervention of this honorable.
They have done?
Lordship, they have now.
They other case.
They have done. Lordship, they have now issued recalculation, which is much higher than what they have taken earlier. So they're flouting the norms and doing it only when the courts comes into act.
Where is that again? Where is your bids page?
For the bid of the.
In this case?
Lordship. Lordship, it starts from page number 118. That is the bidder of the bid of the petitioner, Lordship.
No. Where is the comparative chart?
Lordship, the last page, 235. 235. Is the LOA and the comparative chart is at page 174, which was the evaluation chart. Page 174. Starts with.
No. Where are there were 3-4 names earlier in the
Yes, Lordship. That is package 13.
Huh?
That is at page number 178, Lordship.
178.
The second table, Lordship. That is for the package 13, the package under consideration.
Page
178. Second table, Lordship.
Of package 13.
13.
Orion is 950.
950.
You are?
I am 40 to 75.
40, 75.
42.75.
40.75, 42. Then this 18. This one?
18 is another one. That is.
And then 30.50.
Not sure.
So this is the comparative chart. Now, what is the rate? The rate for additional performance security?
The rate is 300%.
Where?
That is in additional. There's an affidavit opposition. They have filed their annex. That will be at page number.
Additional affidavit
No,
of?
Lordship, that is affidavit in opposition by the respondent. Page 273 is the notification.
270.
There's a table below which says
Threshold means?
threshold is the rupees 50 was the bid amount. So up to 10% there is no additional security.
So below from 10% below.
That will be 45. 50 will be 50. 10%
So it will be 49.
What 45? 10% of 50 will be 5.
Then make it 100 easier. 100 is the bid value. So from 90. From 90 will be okay. It will be from below 90.
Yes.
Is it? Yes. No, from 20%. 20% means from around, if it is below 80% of the,
Lordship. And if
I
it's
mean,
below-
if it's below 20% of the,
if it's now it's below 30%, so it is 300%. That is the third column.
when is the last order that we have filed? No, we did not pass any order.
You have passed an order in
In the
another
other case,
repetition.
Lordship passed one order directing the authority.
Yes,
to
just give me that
recalculate
order. What is the order, case number?
5115 of 2020. Lordship will also take your lordship to page number of the same affidavit, 2024. Page 260, lordship. What they have filed in additional affidavit, they have also stated in that.
They stated in?
In page 260, lordship. In additional affidavit. In the affidavit opposition, what they have stated today is already been on record. It's page 260, lordship.
Yes.
Bidder must be legal entity. They are arguing the same thing.
Where?
Page 260 on the table, point number 2.
Yes.
The bidder must be legal entity in existence for more than 3 years.
Yes.
Their response is that, lordship. Bidder has substantiated adequate work, completion certificate that substantiate the existence for legal entity for at least last 3 years. Further, a society, firm, NGO, or any legal entity may have a temporary registration lapse due to reasons beyond reasonable control of this entity. In this regard, the society registration Assam Amendment Bill of 2022 may be kindly referred to Annex 4.
That's his note. Give him that.
Lordship will now. Lordship, the same table, point number 4. What they have stated, what is immaterial. They have not stated these to be an immaterial deviation, but point number 4, the bidder should have a liquid asset and or a credit facilities.
Huh?
Point number 4 of the same table, page 262.
Yes.
We have raised the demands that bidders should have a liquid asset of and or credit facilities. That is the grievance which was not followed by the condition which was not followed. Now they have responded in the next column. The bidder has declared liquid assets of so and so, also submitted a separate undertaking for cash investment stating so and so. Such a deviation fall under rule 23, rule 15 of Assam Public Procurement Rules of 2020, and also as per bidding terms under section 2 of ITB 29, that is immaterial non-conformities in bid. So now they have specifically stated with regard to these non-adherence to the bid condition that it is immaterial. But they have not stated the same for the.
No, for which condition they said immaterial?
Lordship, that is the.
Huh?
I'll show you, Lordship. Lordship will come to page 59.
You're jumping from one place to the other. I don't know what it's like. Page 59, yes. What is page 59?
Necessity which they are supposed to have, the minimum qualifications.
Yes.
Point number D.
Yes.
The bidder should have a liquid asset or credit facilities net of other contextual commitments and exclusive of any advance payment which may be made under the contract if no less than amount of 50,000, which we said they did not have, the Orient Society. Now the GMC authorities come to a response. They said that was immaterial deviation. The deviation is immaterial, so they will not consider it to be a deviation.
You mean to say this, so this, the Orient had how much? Orient had 43, less than 50.
That the GMC authority says is immaterial deviation from the bid conditions, which we agree.
So they said it's an ancillary condition.
Yes, Lord.
Which can be, it's not an essential condition.
Lordship, which we agree, but in clause number B, which says the bidder must be a legal entity in existence for 3 years, they do not make such a statement in the affidavit. Now they are arguing that is also immaterial.
Which is immaterial?
Lordship will kindly allow. Lordship, the point number D, which says that the credit facility should be 50 lakhs. Now they have 43 lakhs, 50,000. GMC authority says that is not a material deviation. It is immaterial. Will not consider it to be a deviation. We'll ignore that condition. That we agree. Now the point number B of the same requirement says they should be in existence for 3 years. They have responded how they are in existence for more than 3 years. But in that column, they have not stated it is an immaterial deviation in the affidavit. Page 261. Point number two, that is the B point of the minimum requirement, which we have raised. Bidder must be a legal entity in existence for more than 3 years. Now they have responded on the side column in bold. The bidder has substantiated educated work orders completion certificate that substantiate existence of the legal entity for at least 3 years. Further, a society, they have gone, but they have not stated it is immaterial deviation. What I'm trying to submit before Lordship is that in the affidavit, they have stated what is immaterial and what is not.
Just a minute. Yes, you were saying?
I was saying, Lordship, in the affidavit operation filed with GMC authorities, they have stated what is immaterial deviation from the bid condition and what is not. With regard to condition number.
Where have they stated?
In page 260, Lordship, that affidavit.
And what is this? This is additional affidavit? Oh.
They filed it today, Lordship. That nothing new has come up, only the arguments they have placed on the affidavit.
Okay. That's all?
Lordship, page 260, what I'm trying to submit is, Lordship, that we have given a table where they have said these conditions.
So what are you trying to say? It's an essential condition of contract.
Yes,
Then
that is
say that. You know, what are you going round and round, beating around the bush like a, like a love song in a Hindi movie or something like that. Yes, that's all.
Lordship, that's all.
Anything? Okay, right. Heard Mr. D. Deka, learned counsel for the petitioner. Also heard Mr. P. Nayak, learned counsel for the Guwahati Municipal Corporation, bracket GMC in short. Full stop. Also heard Mr. K. Bhattacharjee, learned counsel for the respondent number 3. Full stop. The petitioner and the respondent number 3, amongst others, had participated in notice inviting tender dated 12/7/2024. Hereinafter referred to as the NIT. For carrying out the work of inverted commas, door-to-door collection and transportation of municipal waste in various wards of Guwahati Municipal Corporation, inverted commas. The petitioner and the respondent number 3, amongst others, had submitted their bids against package number 3.
13 notes.
Package number 13. Pursuant to the NIT. In terms of clause 4.2.1 bracket B of the NIT, the bidder was to be a legal entity in existence for more than 3 years and should have liquid assets and/or credit facilities of not less than rupees 50 lakhs. Correct?
Yes, Lord, that is the condition. The
petitioner's grievance is that the despite the bid of the respondent number 3 being 9.10 per household, comma, which is 81% below, is it?
Yes, Lord.
81% below the base slash estimated price of the contract work, comma, the respondent numbers 1 and 2 have not taken the additional performance security from the respondent number 3.
That is,
Yes, huh?
that is subsequent grievance. First grievance was they are not even qualified to be bid.
Just a minute. Respondent number 3, comma, in terms of the notification number 5306 24/1 dated 30/07/2024 issued by the Commissioner Secretary to the Government of Assam, comma, Finance Department. Next para, the petitioner's counsel submits that in terms of the above notification dated 30/07/2024, the additional performance security to be furnished by the respondent number 3, comma, over and above the performance security that is to be normally furnished, comma, would amount to how much?
It's around 1.5. That is the.
Would amount to approximately 1.5 crores.
It may not be correct. It may not.
Approximately. You calculate, you give me, huh? Next para. The petitioner's counsel further submits that the more important issue is the fact that the respondent number 3 has been in existence as a legal entity for less than 3 years at the time of submission of his bid. In terms of the NIT, the next para, the petitioner's counsel submits that the petitioner was registered as a society with the, where is that certificate?
Case 198.
198. With the registrar of societies. No, this was registered under the Registration of Societies Act 1860. Only, no, as Orient Society. Only on 6/10/2021. The NIT was issued on 12/7/2024. And the last date of submission of bids was
38/2024.
30/08/2024. As such, on the last date of submission of the bids in terms of the NIT, the respondent number 3 had been in existence as a legal entity for only 2 years, 10 months. The petitioner's counsel submits that when the essential condition of our tender has been violated, comma, the bid of the respondent number 3 would have to have been declared as non-responsive. However, the petitioner's bid has been declared to be responsive and he has been awarded the contract. That's all? That's all. Next paragraph. The petitioner's counsel submits that in terms of the society's registration bracket Assam Amendment bracket close Act, comma 2019, which came into force on 4/9/2019. Is it?
Yes, Lord.
4/9/2019 provides that the renewal of a registration of a society should be made within the validity period of the registration period of the society or within 1 month of the within 1 month after the expiration of the validity period of registration. Clause 3D. No, not clause. This should be
Section
section 3D. Capital D, huh? And there's no bracket, just 3D. Provides that a society which fails to get its certificate of registration renewed in accordance with 3C and its registration lapses, comma, the registered society will cease to be a registered society with effect from the actual date of expiration of its original registration or renewal thereof, and its name and other particulars shall be struck off from the register in which it was earlier registered or renewed. Full stop. It also provides that no such registration shall be struck off before the expiry of 12 months from the date of expiry of the validity of the previous registration, comma, whether original or renewed. Full stop. Next. The petitioner's counsel submits that the renewal of the petitioner's counsel submits that even if the Orient Society, is it? Orient Society had been registered earlier under the Societies Registration Act, comma, the validity period of the same having been expired, and as Orient Society had been subsequently registered afresh by way of a new registration number, comma, the existence of the respondent number 3 as a legal entity would have to be counted afresh from the date it started to exist under the new registration number. Pustak. He also submits that. That's all. That's all. Anything else?
They cannot register with same name, but that will not.
Ah, so the learned counsel for the petitioner submits that. Once the registration of a society lapses and a new registration is made, comma, the society should be registered in a new name. Full stop. However, it appears that in the present case, the registration of Orient Society has remained the same,
Flouted the norms and registered.
has remained the same, comma, by flouting the norms and the requirements in law are requiring change of name. That's all. What else? Ms. Pan. The petitioner's counsel submit that in view of the above, in view of the fact that the petitioner, the respondent number 3 did not have the required number of years as a legal entity, as a registered legal entity, comma, the award of the contract, it has been awarded to him.
LOA was issued also.
The letter of acceptance issued to the respondent number 3 should be set aside. And the state respondents should be directed to reconsider the allotment of the contract to the remaining tenderers. Next, Mr. P. Nayak, the learned counsel for the GMC, submits that the Orient Society had been in existence since which year? 2014. 2011. As it was registered with the registered under the Registration of Societies Act. Where is that registration?
The copy for you, sir.
Give me back that thing. Societies Act 1860. By registration number RS/KM, don't say RS, forget that. KM bracket M slash 240 slash 8-29 slash 599 of 2011 dash 2002. The last time it was valid was till 2017. So from 2017 to 6th October 21, it was not valid. There was nothing. There's a gap.
Yeah, my lord, for COVID reason, we have filed a presentation.
COVID, but then this is
We have-
18, there was no COVID, 19, there was no COVID.
My lord, 1920, there was a COVID.
Huh?
1920, there was a COVID. my lord.
Sorry, 19, there was no COVID. It happened only in March 20.
Yes.
But we started from there, my lord. I see.
It started from,
19,
no,
December onwards.
no, maybe in China, not in India. Maybe in China, not in India.
Petition was given
Huh?
for renewal.
No. The COVID didn't start. Because I went to Bangkok in 2019, December of. CA started then.
Yes, not.
CA happened in December 19. Because I remember going to the airport, I had to take the long route so that I didn't get stuck.
Lordship, let me summarize, Lordship. If Lordship comes to page 15, Lordship will get the ground of the petition. Page 15.
15.
Only 4 grounds, Lordship.
Page 15.
Yes, 1-5.
Page 15 of the writ petition.
Petition, Lordship. Yes. Page 15. One table is there. First
Yeah.
ground, the NGO was registered in 2021. So second ground, same as it was in 2021. So he does not fulfill the criteria of 3 years. Serial number 3 is the PAN card, Lordship. This as your Lordship has already gone through. And fourth ground, Lordship, his liquidated asset is less than 50 lakhs. These are the 4 grounds. The quoted rate was inadvertently low, or it was low. That was not his ground. Arbitrariness not a ground. Malafide is not a ground. Now his assumption is that we considered the legal entity only on the basis of NGO certificate. Lordship, I am coming to the page.
No, we cannot go against him.
No, Lordship,
I'm
just 2 pages, Lordship, just 2 pages.
Be in a hurry because I'm in the process of judgment.
Lordship, only 2 pages, Lordship. Lordship comes to page 186 of the writ petition.
Yes.
Page 86, 186.
Yes.
So Lordship, may kindly, this is a table. This is the bid document, Lordship. By Orion Society, Lordship, it comes to second row, name of the NGO, Orion Society.
There. Correct.
Next page, Lordship. Information from the bidder. Bidder's name, Orion Society, bidder's constitution, partnership.
Correct.
Incorporation 2016.
Incorporation as what?
Third row, bidder's year of incorporation, partnership. So nowhere we have stated that we considered it as a legal entity only on the basis of the NGO certificate.
Then how can you?
So he's trying to confuse Lordship.
Lordship,
His repeated argument
Huh?
that it was on the basis of
he has
Orion
submitted-
Society is also claiming itself as a partnership. We are only considering whether its existence as a legal entity is more than 3 years or not.
Lordship, can they file?
Lordship, we found Lordship, his first LOA was in the year 2014.
You see, was this tender submitted as a partnership or as something else?
Because
Look, we have not considered that issue. We only considered it whether it is a legal entity or not.
either way, they can be anything for 3 years.
Lordship,
That
for
cannot
us,
be-
Lordship,
So is Orion Society, is it a proprietary firm or what? Is it a partnership? What is
that
it?
is the bid. That is the bid, Lordship.
Let him decide that, not you.
I am only on the basis of bid document, Lordship. It is the bid submitted by him, Lordship.
Yeah, okay, this is a bit submitted. He says partnership,
He
but where is the partnership deed?
Yes, Lordship.
Deed has not enclosed, but year of incorporation has been given as 2016. But
Very
Lordship, we,
Lordship will come to page 201,
Again.
GST certificate, which is a society. Page 201, that is registration for the GST, Lordship. They have submitted to the society, it doesn't say partnership. All the documents, it says society. They are relying on the society documents of 2011, 2014. Now they cannot come up and say it's a partnership. They have filed an affidavit. They're only trying to. Lordship, page 203.
Okay, I think I've got it.
Lordship. And also 203, they say there is secretary. Partnership, in a partnership firm, they're not secretary, they're partners. For the GST registration, page number 203.
Anything else?
in that same page, Lordship, 187.
Yes,
Lordship may kindly come to little down, Lordship.
yes,
Bidders authorized signatory,
yes.
Krishna Borua. She has signed the bid, Lordship.
As a secretary.
Whatever it is.
Secretary will not partnership firm, they're not secretaries, they're partners. Secretaries doesn't become, two secretaries will not become a partnership.
What do
firm.
you mean secretary? What
Secretary of the society, Lordship. They designate themselves the president and secretary of the society. That is an NGO. In partnership firm, there will be no society, secretary or president. There will be partners,
You
managing
mean
partner.
signatory?
Authorized signatory. He's a secretary of the NGO. As in, he has designated himself as.
So that is one ground, Lordship. So I'm repeatedly, that is why I'm submitting, Lordship. It was not on the basis of an NGO certificate. Some other factors were also there.
Are you a partnership? Huh? Who's your partner?
My lord, I'll so take that my.
Where is the partnership deed?
It's not.
Not there.
But
Okay,
my lord,
okay.
there will be my lord. Even in a partnership firm, there can be a society, my lord. They can form it under the society, my lord.
Correct. They can
Then-
form. They can
then
form a
that's my
society.
lord.
Correct. They can form a society.
Under the partnership firm and any sort of.
Okay, they are a society. The partnership firm can be a society. Okay. So there are so you filed your bid as a society or as a partnership
As
firm?
per the
Both,
records,
both. In
Both.
one page it is mentioned as
And
NGO,
that
in
not
one page it
Okay.
is mentioned as
As
partnership.
both. So you filed it as both.
So
Okay.
that is why these
So-
were not the basis for us
No.
to consider it being a legal entity or not. Our basis was something different.
Okay.
They were working with us since 2014, Lordship. So that is one ground, Lordship. Lordship has. Second ground, Lordship, that financial capacity, Lordship.
No, that's okay.
That
He's
is
not
possible.
pressing. He's only pressing that
NGO. Nothing
legal
else.
entity. That's all.
Lordship, we are considered on.
He's doing only that. He's not going on any other.
No, if only the NGO certificate is to be considered, Lordship will also consider that partnership certificate which was incorporated in 2016.
Where is that?
If the space is 187,
187 is not a partnership deed.
did, but their statement. Lordship.
Just because they say that they're somebody doesn't mean that it has to be supported by thing.
I'm relying upon neither on this page or not this page 87, Lordship.
Then what are you relying
We
upon?
are saying, Lordship, they are working with us since 2014.
That
that
is
is-
what you're saying. You're
That is
basically,
sufficient for us to consider. it
and I
as a
don't
legal
know why you're so interested, you know. the GMC. You are more, you are actually, you are more the tenderer. I don't know, you are really interested.
My,
I mean.
my friend health condition.
I don't know, I do not know. Oh, that's why you have hired him to do your job. Okay. So I thought he had hired you. GMC hired you. You hired the GMC. Okay.
So my only contention, these are all baseless allegations, Lordship, that to buy a
Let me
person
decide the
Yeah,
issue. I've heard you all.
Yes.
I've heard you all.
Yes.
And after a while dictating also, I've heard you all. I think that's enough.
No, he has ours arbitrariness, malafide, whatnot, Lordship.
He
But
can do anything.
arbitrary, not a single word is to be found there. Arbitrariness.
We'll have to see. We'll have to see. What am I? Where am I? So he submits that just because the Orient Society had subsequently registered itself afresh with a different number, that is RS/KM bracket M /263/X/233 of 2021-2022, page 198. The same did not mean that the Orient Society bracket respondent number 3 had not been in existence since the year 2011. As such, as the conditions of the tender did not require the continuous existence of Orient Society, the existence of Orient Society having two different registration numbers would satisfy the requirement of the clause requiring a bidder to be in continuous existence as a legal entity for 3 years. Full stop. Next para. Mr. P. Nayak, Bennett Counsel for the GMC, has also taken this quote to page 187 of the, what is this, of the writ petition?
Yes, Lord.
Of the writ petition, to show that the legal status of Orient Society was a partnership. So, sir, he submits that as the GMC had been working with the respondent number 3 since the year 2014, 14, comma, and the GMC had accepted the bid of the respondent number 3, not only as a registered society, comma, but also as a partnership. That's what you said.
Neither NGO nor partnership, Lordship. It was on the basis.
You make up your mind. You cannot.
That is what I submit.
Which
On the
one?
basis of the fact that it is working with us since 2014.
Okay, so so you have given a partnership.
Neither
Please, when you make a submission.
Continuously submitting, not.
No, Mr. Counsel, you have got to take a stand either this should, you took one, no, please listen. You said that he is a partnership also. He is a partnership also. So we accepted him to be not only a registered society, but also accepted him as a partnership. Now, when I'm dictating,
No, no.
you are saying no.
I'm sorry, Lordship, I could not convey, Lordship. My submission was, he is working since 2014. So there was sufficient evidence for us that he is a legal entity since 2014. That is one. Neither he was considered as an NGO nor as a partnership. What I have shown that later, Lordship, if only the society registration is to be placed, why
So-
not the partnership, Lordship?
Huh?
Why I have made that submission. If only the NGO registration of 2000 is to be produced, Lordship, why not his submission of document that it was incorporated in 2016 is not to be considered. That it was only for that purpose, not nothing else.
Okay, so basically you are saying he's a legal entity, that's all. So you cut that 286 then. 280, page 287, 187, you cut that from page 1. Okay, what else? Anything else? What did you say? Now I've lost my train of thought. What? Now, where was I? What was I thinking of to say? Now I've lost.
That is first ground, and the second ground is that lordship.
The petitioner, the Mr. P. Nayak, further submits that in terms of the
That ground I am not pressing lordship. 22 I am not pressing lordship.
22, you're not pressing.
Lordship, only I am on the grounds of page 16, 15 and 16. One ground is NGO registration and the second ground is of his liquid asset. That is less than.
Liquid asset to his then.
We're not.
Which condition he also doesn't fulfill lordship.
Yes, Lordship, they have stated immaterial.
At least this petitioner, this.
Okay, right, right. So then I will not, 22, I'm not saying anything. Okay, next slide. Mr. P. Nayak, the learned counsel for the GMC submits that the fact that the respondent number 3 had stated that his page 261 minor deviation had declared his liquid assets to be rupees 43, 50, 000. While the requirement of the NIT required
50 lakhs.
the bidder to have
50 lakhs.
liquid assets of rupees 50 lakh, he submits that the same is a deviation.
Not, that is also not a deviation. Page 194 lordship.
What we have stated in affidavit that it was included.
Page 194. He fulfills that criteria also. Page 194 lordship. This is the certificate given lordship.
That is not the contention on affidavit. 263, 265.
I think you should stop disturbing me now. I've heard enough. Because it is all your affidavit. This is at page 262.
Lordship, in 194 lordship.
Mr. Counsel, this is your affidavit. I am making this order on the basis of your affidavit. I am not stating anything different. I think you all have disturbed me enough. I've been quite patient with you. Please, let me continue now. What have I said? (43, 50, 000) as against the requirement. Is a deviation which falls under Rule 23, Sub-Rule 15 of the Assam Public Procurement Rules 2020 and also as per the bidding terms under Section Roman 2 of ITB 29. That is, inverted commas, immaterial non-conformities in bid. Inverted commas. The Mr. P. Nayak submits that he does not wish to make any submissions. No, do not wish to press his submissions with regard to the society registration bracket Assam amendment bracket close bill, 2022 being applicable to the case in hand. Full stop. Next para. The council for the respondent number, the council for the GMC submit that as the GMC has been working with the respondent number 3 as a legal entity since the year 2014. There is no infirmity with the allotment of the work, with the a letter of acceptance being issued to the respondent number 3 for the contract work in question. Full stop. Next para. Mr. K. Bhattacharya, learned counsel for the respondent number 3 submits that the Orient Society had initially been registered under the Registration of Societies Act 1860 in the year 2011, and the same had been renewed up to 30/12/2017. Full stop. However, due to COVID, the renewal of the petitioner's registration under the Registration of Societies Act 1860 could not be done, and the same and as such, a fresh registration was done in the same name, that is Orient Society, on 7/10/2021. He submits that the Orient Society is registration has been renewed up till 14/10/2027. He also submits that he also submits that he reiterates the submission made by Mr. P. Nayak, the learned counsel for the GMC. That's all. I have heard the learned counsels for the party. Judgment reserved. Hearing concluded, judgment reserved. Huh? Meeting now.
Given the calculation,
Huh?
given the calculation of the amount.
I don't know. I don't think this I'll be able to pass the order. No time this month. Maybe when I come. On the
Publication.
yes, just 2 weeks.
One more judgment, Lordship, I'm citing, Lordship.
You can give me all judgments, no problem.
The interim arrangement will continue in the.
Huh?
The interim, there is the interim.
Actually, one thing. Mr. P. Nayak, learned counsel for the GMC has relied upon the judgment of the Supreme Court in Tata Motors, bracket page 52, para 52, 53, and 54.
Lordship, one more, Lordship.
And in the case of
NG Projects Limited, paragraph.
NJ Projects Limited,
Paragraph 20.
citation
2022 6 SCC 127.
127, para
22.
22.
So can we continue the interim arrangement? We have an
Interim order to continue. We say hearing concluded, interim order to continue till delivery of judgment.
Highly obliged.
Let me see if I can finish, but difficult. Too many matters.
Lordship, our only concern is that first survection law. It is in the coming in the month of December and January. Anytime they may come.
No, by the first week of December, January, it will be out. Or if it was, if you see, because actually I'm leaving tomorrow. That is why. If I was till Friday, then I would have finished it. I've got around 5 CAVs, which I'm planning to pass all tomorrow. So, only thing is that your matter, difficult. Let me see if I can finish. Maybe I'll ask someone to pass order by Friday or something. Let's see. But then I don't know. Because I've got to read and it becomes difficult.
Lordship, here, Mr. R.K. Musari is handling the case. He is sick, Lordship.
Oh,
Mr. R.K. Musari, he is handling the case.
he wants basically NOC to sell his land.
Lordship, that he is holding the paper. Lordship, I'm paying for an exam. He is sick since 4 days back. Lordship, he has not come.
Immediately after vacation.
Yes.
Okay, right. The matter pertains to the petitioner's application for grant of a no objection certificate to sell his own land, not being decided by the authorities. Adjournment prayer has been made on behalf of Mr. R.K. Mushahari, learned counsel for the respondent.
Yes. Yes, sir.
On the ground that he is unwell. This is the matter. Give a date.
All right. 34.
Yes.
Notice was issued on the last occasion.
Yes.
Some time to take the instruction, Lordship. We can now wait.
His period is going to end.
June 26.
My lord, on 26, my lord,
June
5/26.
26 years.
26.
26.
Okay, then, but you obtained instructions.
We have already asked for the
The
instruction.
problem is that you all made a mistake earlier.
Yes, the issue is that only. GPS code changes.
Of course, and he did not make correction of that also. You kept quiet.
I have no authority.
No, but then where did you work then? You worked in the wrong place or what?
I don't know, my lord. I don't know.
What do you mean you didn't know?
All was settled with me. I've operated the mall. After when the renewal period start, well, then only the DFO sends the GPS coordinate and asks the sea authority to
renew it in the same GPS code.
Then you renewal in the same GPS.
GPS is.
But then that is the wrong place.
That's the wrong place.
GPS is the first lawsuit.
What to do?
How can I
What can be done? You see, because when we meet again the next time, the same issue is going to rise up. Now, what is the solution?
Should teach them also in the
We'll
meantime.
come with an instruction, Lordship.
We'll count and stuff. Otherwise, our rule, my rule is very limited, Lordship, because if GPS is same, then we can renew it.
It's a complete new GPS, but it's a complete new area, your Lordship.
New
That's the
area, new
issue.
GPS, so Lordship, it's a face.
It becomes a
I am
fresh.
forced to suffer, my lord. I have been paying the kist money.
But why didn't you say in the very beginning that the environmental clearance was given in the wrong place?
I have already wrote a letter to the DFO, several letters, my lord. I have the.
Okay, right. Adjournment prayer has been made on behalf of by Mr. R.R. Gogoi, Learned Counsel for the Forest Department, and Mr. K. Gogoi for the respondent number 2. They submit that they will obtain instructions with regard to the prayer for renewal of the environmental clearance.
The clearance.
Environmental clearance. Huh?
May I pray for a fixed date after view vacation?
After view.
List the matter on.
Obliged.
Obliged.
36 orders.
Where's the accountant general? Yes, you're for?
Lordship, I'm appearing for the PH department, Lordship.
So the account new head has been made or not?
New head is made, your Lordship.
New head has been made.
Yes,
So then
and Lordship, we've already submitted a fund demand, your Lordship.
Fund for payment, fund proposal,
Proposal we have submitted.
to whom?
To the Secretary, Your Lordship.
Which secretary?
Secretary, Governance of PHE.
Right. Mr. R. Gogoi, learned counsel for the PhD department, submits that the head of account that has been created has been approved by the Accountant General's office. Approved.
Approved, Your Lordship.
Approved by the Accountant General's office, and consequent to the same, a fund demand has been made by the Chief Engineer PHE bracket water to the secretary to the government of Assam PHE for rupees 14.34493 on 5/12/24. Mr. R. Gogoi shall obtain the status of the fund demand made by the next date. List the matter on.
Public Lord.
Timing item 47 promotion.
Met with the lordship. Petitioner before lordships, the my lord is
Has the fishery been settled?
No, not.
No.
Actually, we have also inquired.
So what do you want out here?
My lord, he has my lord, person number rate, my lord, technically he has, actually we have submitted my highest bidder. He submitted a response as a society, and he has some benefited, so thereby his name is given for first, my lord.
Actually, that, let me say, Lord.
And then my lord, after my lord, the tender process, my lord, when he was supposed to photocopy of the AGM report, my lord, for authority. But he submitted in original, thereafter we have some doubt. On the basis of I'm filed representation, thereafter inquiry was made, an inquiry against him, my lord.
Yes.
He has, my lord, he can court me, permit me page 42 the inquiry, my lord, 42. This is the forwarding letter issued by the Eastern Register Cooperative Society to the Managing Director Assam Fishery Development Corporation, forwarding the inquiry report regarding background Noyangu Fishery Cooperative Society, page 43. Turn into page, this is the inquiry report, my lord. This page 43, my lord.
Yes.
And second paragraph, my lord, as per statement, shareholder as well as complaint present 45 numbers, they clearly mention the secretary Sri Jadav Das and president so and so society did not hold AGM society from past few years. He did not give notification so and so. They do not care about the shareholder of the society, and they also mentioned that secretary president also put their fake signature in the proceeding books of the AGM. They inform us the signature of the deceased shareholder are also present in the AGM, and which was held on so and so. Death certificate, this is enclosed. The shareholder want to change the so and so. So, and next page, man, 44, my lord. During the inquiry, we have observed that following, my lord. So, the secretary of the society has not maintained the member of the register of the society properly. Management society did the list circulation promotion annual so and so. In the AGM dated 7/7/2000, signature of the deceased and non-shareholders have been reflected by AGM positive. Well, completely, my secretary by without signature of the other board of director, he has submitted the tender process, but by submitting original, thereby they are in dark, my lord. And thereafter, after verification, we seen that this is a total.
What is to be done?
Yes, Lordship, it is true. Actually, we can revisit the technical bill, Lordship, give liberty. Actually, fraud negates everything.
Huh?
Fraud negates everything. Lordship, depending, we can.
So that the financial bills have been opened?
Yes, Lordship. But we can revisit the fraud. If there is any fraud, Lordship, we can revisit the
and give an opportunity of hearing to that to the private respondent.
After hearing the private,
after hearing the Lordship, here one thing, Lordship, it is a technical bill, tender process, Lordship.
Correct.
I can respond.
No. You see, you have not taken a decision as on date.
No.
Then.
No, Lordship, my concern is that whether anybody is needed, we ourselves can, is a technical.
Correct.
We ourselves can revisit it.
Correct. So I don't have to pass an order or what?
The Lordship can give us a liberty to revisit, Lordship. Otherwise, we can't do it.
Okay, right. Heard Mr. N. Bora, learned counsel for the petitioner, who submits that the petitioner participated in the tender notice number 07/2024 dated 22/8/2024 issued by the Assam Fisheries Development Corporation for settlement of which fishery?
Borkona Fishery, Borpeta, my lord.
Borkona Fishery under Borpeta district for 7 years with effect from 2024-25 to 31/3/3031. Pustak. The petitioner's counsel submit that the petitioner and the respondent number 8 have both been declared technically qualified bidders. Pustak. The petitioner's counsel submits that in terms of the letter dated 18/11/2024 issued by the senior inspector / auditor of Cooperative Society.
Mal. Cooperative, Register of Cooperative Society, Borpeta, to the Managing Director Assam.
No, auditor of Cooperative Society,
Mal.
comma. The following observations have been made. Page 44, huh?
Mal.
Take it down, okay? Pustak. The petitioner's counsel submits that in her,
His person, clause 16 is also being violated, that also may be given. Clause
the petitioner's counsel submits that in view of the above, clause 16
of the NI.
and clause 6.6.
6.6.
Yes,
Clause 16 serial number 16 and clause 6.6.
clause 16, Lordship.
Clause 16 and clause 6.6. Clause 6.6 and 16 of the tender conditions have been violated. Pustak. Next paragraph. Mr. P. Sharma, Learned Counsel for the Fishery Department submits.
AFDC, Lordship.
IFDC submits that if fraud has been committed, comma, the matter can be looked into again by the FDC as fraud vitiates everything. Pustak. In view of the submissions made by the counsel for the parties and keeping in view the letter dated 18/11/2024 issued by the senior inspector / auditor of cooperative societies, comma, which is addressed to the assistant registrar of cooperative societies, Barpeta. This court is of the view that as the final selection of the successful tenderer has not been made by the AFDC, comma, the AFDC should look into the contents of the observations made by the senior inspector / auditor of CS, dated 18/11, made by letter dated 18/11/2024, issued to the, addressed to the assistant registrar of cooperative societies, bracket Annexure E series. The
No, it was later on addressed to us, Lordship. Addressed to us.
I've got this only.
Page 42.
42, page 42. The AFDC should consequently take a decision with regard to the selection of the final, the selection of the successful tenderer after considering the observations made in the said letter. That's all?
Within a
Yes,
period of
Lordship,
time.
very limited. Actually, he is the highest bidder.
Maybe, whatever.
Actually, he got,
Full stop. Any decision to be made by the respondent, by the AFDC, which could prejudice the respondent number 8, should be made only after giving an opportunity of hearing to the respondent number 8. The writ petition is accordingly disposed of. No time limit, no time limit.
Otherwise,
we will not settle, Lordship. Without hearing.
They might want to
No,
do something else.
It's very clear.
Item?
Lordship. No, my lord recalls, my lord, this matter relates to the
Review is pending.
review
No,
is
Your
dismissed.
Lordship,
Review is dismissed.
Dismissed by your lordship on 4th of December.
Oh,
dismiss the review, Your Lordship. Now the department is in with a view of filing a writ appeal. Lordship, in our affidavit, Your Lordship, which has been filed by the revenue department in paragraph 9 and 10.
has been categorically stated that the order which was passed in the disposed writ petition, that is not implementable, Your Lordship, under the provisions of the Act and the laws which are relevant. So, Your Lordship, department is thinking of filing an appeal, Your Lordship.
Maybe you're thinking, you see, madam, thinking will not do.
The process is on.
No, no, madam, that will not do. You're thinking and it will be filed, will not do. Till it is filed, till it is stayed, you have to comply.
Well, earlier they took a lot of time in contemplation of filing the review, my lord.
Lordship,
Now they are saying that they will file a writ appeal. That too, after limitation has gone, my lord.
Lordship, the,
3 years, my lord.
may I, Your Lordship?
I don't know, you ask him.
Can I? Lordship, the drafting is almost completed. It will file shortly.
Anyway, right, heard Mr.
R. Chakraborty.
Huh?
R. Chakraborty.
R. Chakrabarti, learned counsel for the petitioner, who submits that the, where is that order page? Who submits that the review petition
Page
filed
33, my lord.
against the order dated 4/8/2021, passed in WPC 2789 of 2019, has been dismissed on
4th of December.
4/12/2024. And as such, the said order dated 4/8/2021 would have to be complied with. Who's that? Miss
And Borderline.
N. Borderline, learned counsel for
The sole response.
the sole respondent submits.
Respondent number 1, Your Lord. Respondent 1.
Sole respondent.
No, Your
No.
Lord.
For respondent number 1 submits that the state government is intending to file an appeal against the order dated 4/8/2021, passed in WPC 2789 of 2019. And the process has started for the same. Next part. On considering the submissions made by the parties, it is clear that till a stay order is passed by a higher court, by the division bench, in the appeal that may be filed by the respondent, by the state government, the respondent would have to comply with the order dated 4/8/2021, passed in WPC 2789 of 2019. So what to do till then?
Outcome of the writ appeal.
I said it has to be complied with unless there's the order.
No, Your
So
Lordship.
let him appear why he's not complying with.
No, Your
Yes,
Lordship.
that will be better. And my lord,
Lordship, may I
it
submit?
will be
Your Lordship,
prejudicial
5
or
minutes?
otherwise.
5 minutes, can I submit? Your Lordship?
5? Why 5?
No, he's obstructing, Your Lordship. Anyways, Your Lordship, the categorical statement has been made and this affidavit has been filed by the principal secretary himself, Your Lordship, whereby.
Madam, there is, you see, have you read the orders passed by the Supreme Court? Then
So, Lordship, actually.
are we bound by the principal secretary's letter or the law laid down by the Supreme Court?
The cabinet memorandum was also.
Whatever, maybe a cabinet memorandum has been made. But are we bound by the law laid down by the Supreme Court or the memorandum made by a cabinet? You tell me.
Lordship, may kindly grant some time, Your Lordship, so that the appeal is heard and then an order is passed there.
The counsel for the respondent shall obtain instructions as to why the order has not been implemented, is not being implemented. When the law laid down by the Supreme Court clearly requires the implementation of an order unless the same is stayed or set aside. List the matter on when?
Reopening day, my lord.
I'll give it. Yeah.
First week of February, Your Lordship, may I?
No, no, no.
First week of February, Your Lordship.
Enough time, madam, you try.
Always.
I'm obliged.
Okay, even here we have already submitted a supplementary demand on 12/12/2024, Your Lordship. The newly created head of account, Your Lordship.
Okay, so supplementary demand made by the.
Made by.
Now this has to be sent by you to the finance.
They will send it to the financial.
Ah, it will be sent to the finance. So it's moving.
Yes. Slowly, but it's moving along.
But is this with regard to all the cases?
All the case, not only his, we got all the court cases, Your Lordship.
So it's neither here nor there.
We are trying to disburse every amount regarding this.
Okay, right. Mr. R. Gogoi has submitted a letter dated 12/12/24 issued by the Chief Engineer (PHE, Sanitation), which is addressed to the Secretary of the Government of Assam, PHE Department, wherein a supplementary demand proposal amounting to rupees 664 lakhs against the newly created head of accounts has been made. Mr. R. Gogoi shall obtain the status report with regard to the demand made by the Chief Engineer, PHE, and whether the supplementary demand has been sent to the Finance Department for its approval. This is the matter after the BO with you.
Obliged, Lordship.
41. Sorry. The matter relates to selection of Gambla. Lordship was pleased to deal with the matter, Milord, whereby my selection was interfered with, Milord, on the ground that I still belong to a political party. Milord, in spite of exercise of due diligence, one document we could not bring to your Lordship's kind notice. That is how my Lord we are finding. If your Lordship would kindly come to page 33, Milord. That is the part of the advertisement. Sorry, page 33 is the serial number 29, Milord. That is for Sanpara Parhat 1. This was the name of the office. Then, if your Lordship kindly comes to page 36, Milord.
Name of village, you mean?
Yes, yes. In respect of which the ground pradhan was advertised. Now, if your Lordship would kindly come to page 36. Under the heading Other Criteria. If your Lordship would kindly come to somewhere in middle, candidate should not be a member of any political party. Candidate should not be a member of political party. Yes. Now, my Lord will kindly come to page number 41. This was my selection, my Lord. I am Kondorpo Boiso at page 41 against serial number 33. Now,
Yes.
the Lord will kindly come to the impugned judgment at page 168. Para 29. The Lordship's got it.
Yes.
The documents show that the respondent number 8 had not resigned from the political party he belonged to at the time of his selection as Gaon Pradhan. He having only resigned from membership of the Gaon Panchayat, as such, respondent number 8 was ineligible to be considered for selection and appointment to the post of Gaon Pradhan. So basically, this was the reason, my Lord, that I resigned, but sorry, Yes, I have only resigned. I have not given up the membership. And that is the reason, Lordship. Naturally, my lord, if this is the position, the view is otherwise correct. Now, if your Lordship would kindly come to page number 174, my lord. In fact, if your Lordship would kindly come to page 170, this was the information which was provided to me under the right to information. Now, this is the forwarding letter, and at page number 171, my lord, kindly see Kondorpa Boyso, serial number 30 selected. These are the original marks, my lord. Then if your Lordship would kindly come to page 172, the respondent number 4, he got, my lord, 24. Then finally, if your Lordship kindly comes to page 175, this is the letter by which, my lord, I gave up my primary membership. Originally is also there at page 176. With due respect, I beg to state that I am a primary member of Bharatiya Janata Party. My membership number is so and so. I have submitted this application seeking resignation from primary membership of Bharatiya Janata Party due to my special problem. I am obliged if the president accept my application. Now, my lord, the
Page 175.
yes,
This was not part of the writ petition.
no, it was not part of the
Okay.
Now, in spite of exercise of due diligence, my lord, we could not bring it to the notice of your lordships. Now, if your lordships would kindly see the endorsement, the applicant Sri Kondorpa Boyso has been released from primary membership of Bharatiya Janata Party today on 25/11/21. And now, my lord, the vernacular is there. If there is anything wrong, my learned friend can clarify, my lord. The endorsement is at page 176 in vernacular, my lord. আবেদনকারী শ্ৰী কন্দৰ্প বৈশ্যক আজি 25/11/29 তাৰিখে ভাৰতীয় জনতা পাৰ্টিৰ প্ৰাথমিক সদস্য পদৰ পৰা অব্যাহতি দিয়া হ'ল।
I don't know, but then whether this is a fabricated document or
Let
now
them verify, my lord. Let them verify. Lordship will issue notice at this stage, my lord. And we have made that statement, my lord, that in spite of exercise of due diligence, we could not bring it to lordship's notice at para 18, my lord.
My lord, I have raised the maintainability of this review application on two grounds. These two documents which they have referred, first, these two documents which are discovered.
which two documents?
My lord, page 170 and the resignation. And first ground, my lord, there is a delay, my lord. There is a delay. Delay of filing, my lord, review application, my lord. My lord, this information was received on, my lord, this letter, my lord, RTA letter, my lord, 39/2023, my lord. Page 170. I mean,
our basic ground.
Judgment was passed on 26/9/2023, my lord. And
Judgment was passed on
26/9/2023.
26/9/23.
And my lord, it was heard on 19/6/2023. My lord, the information was given, received on
Heard on 19/6/23.
Yes, my lord.
19/9/23.
1999.
So this document is after the
Yes.
judgment.
And another thing, my lord, the information which is the document which is produced by the final evaluation sheet, it was on the record, my lord. On the page, my lord, 171.
Yes.
This was on record, my lord. But the marks, individual marks given by the member of the selection board, my lord, that has been annexed in this review application, my lord, which they claim they have obtained from by RTA application, my lord. But this information cannot be given on the RTA application, my lord. This is hit by section 8G, my lord, of the RTA application, my lord. And my lord, kindly see the page 71.
page 71,
171.
171, my lord, that the member one additional deputy commissioner, my lord, signature, my lord. And kindly see page 171, 172. The signature, my lord. Member one. Signature, this signature and this is perhaps it appears to be different. And and my lord, kindly see member two, my lord, member two signature. And my lord, page 173. My lord, see. My lord.
Correct.
My lord, this, my lord, if that be so, my lord, the government should come for review, my lord. They have not come, my lord. And my lord, there is, the DAP cannot be overruled, my lord, because.
What cannot? A doubt cannot be
overruled, my lord, because.
overruled.
Because he has a political nexus, my lord. He is a member of the ruling party, my lord. And apart from, I don't want to mention, my lord, he belongs to the Jalukbari constituency.
He belongs to the.
Jalukbari constituency.
So, okay.
And my lord, the second document is, it is his personal document, and he has to satisfy the test whether he has accessed the due diligence, my lord. And my lord, that document should be, my lord, not within his knowledge. It is his personal document, which is afterthought document, my lord. And there is no statement in the review application, my lord. He has exercised the due diligence, my lord. Apart from that, it was not within his knowledge. And in the entire, even in his affidavit in opposition, my lord, he has not mentioned anything that he had resigned from the political party, my lord. In the affidavit in opposition, the review applicant had
not stated.
Not stated, my lord. And in a recent judgment, my lord, almost said on
No, actually, I didn't complete my learned friend stood up. There was another point. Anyway, let my learned friend complete.
Let him complete.
Yes, let him complete.
But I relate paragraph 11, 12, 13, 14, 16, 17, and 20 and 20.
My God, just a minute. Paragraph 11.
11, 12, 13, 14, 16, 17, 20, and 25.
Yes.
Paragraph 11. While proceeding to determine the correctness of the impugned order vis-a-vis the exercise of review jurisdiction, we ought to remind ourselves of certain cardinal principles. The exercise of review jurisdiction is not an inherent power given to the court. The power to review has to be specifically conferred by law. In civil proceedings, review jurisdiction is governed by section 114, read understood with order 47 CPC, and court has to certain that the elements prescribed therein are satisfied before exercising such power. This court in so review proceedings are not by way of an appeal and have to be strictly confined to the scope and ambit of order 47 rule 1. The provision contained in section 114 order 47 of the CPC relating to review of an order degree are mandatory in nature, and any petition for review not satisfying the rigors therein cannot be entertained ex judicial justicia by court of law is tried. There is a plethora of decisions analyzing the statutory provision governing the exercise of review jurisdiction. However, we would be referring to a few of them for the purpose of present exercise. Suffice it to note that despite legal proceedings having commenced with institution of the civil suit as far back as in the year 1956, the present controversy has as its source a writ petition between the first respondent and the Tehsildar referred in 2009. Although the explanation to section 141 of the CPC makes it clear that the provisions of the CPC would not apply to proceedings under Article 226 of the Constitution, there is authority in abundance that the principle following from the CPC may safely be taken as a guide to decide writ proceedings, but to the extent the same can be made applicable. To put it plainly, Order 47 Rule 1 of CPC provides 3 grounds for review matter. First matter, discovery of new and important matter or evidence which, after exercise of due diligence, was not within the applicant's knowledge or could not be produced by the applicant at the time when the degree was passed or order made. For minor, then other 2 document minor and ground minor. Then paragraph 16 minor. This clause 1 has been, since the division bench review invoke the first clause minor, that's a discovery document minor, we hasten to emphasize that an applicant seeking review on the basis of discovery of new evidence has to demonstrate first that there has been discovery of new negligence of which he had no prior knowledge or that it could not be produced at the time the degree was passed or the order made despite due diligence matter. And minor. Secondly, that the new evidence is material to the order degree being reviewed in the sense that if the evidence were produced in court when the degree was passed or order made, decision of the court would have been otherwise. Ultimately, minor, it is for the court to decide whether a review sought for by an applicant, if granted, would prevent abuse of the process of law and miscarriage of justice. Then when the ground for review sought is that of discovery of new evidence, this court in State of West Bengal versus Kamal Sengupta has clarified that the same must be evidence which should be materially important to the decision taken. The following passage is instructive matter. At this stage, it is apposite to observe that where a review is sought on the ground of discovery of new matter or evidence, such matter or evidence must be relevant and must be of such a character that if the same had been produced, it might have altered the judgment. In other words, mere discovery of new important matter or evidence is not sufficient ground for review existence. Not only this, my lord, the party seeking review has also to show that such additional matter or evidence was not within its knowledge, and even after excessive due diligence, the same could not be produced before the court, my lord. But in the review application, my lord, there is no such statement. If you see the review application, my lord, what the statement has stated regarding this, my lord.
Yes.
My lord, page 18, my lord. Paragraph 17.
Yes.
The review petitioner begs to state that while passing the judgment and order date 26/9/2023 in this honorable court came to an erroneous finding without calling for the records of the selection as regards non-allotment of marks to the respondent number 1 in terms of clause G of the advantage. The review petitioner obtained the final evaluation sheet of the candidate for the post of Gapodana Sanpara Parbat under Hazor Revenue Circle and the evaluation sheet of 3 members of the selection board through RTA application. The final evaluation sheet of the candidates for the post of Gapodana of Sanpara Parbat village clearly reveals that each of 3 members of the selection had allotted marks to the so under constitution. But they have not stated when they had filed the RTA application in the review application. It was, my lord, not a question. It was not within his knowledge, my lord. It was all along available in the DC office, my lord. I have submitted the RTA replay, my lord, the marks. Then your lordship, except this, there is no statement regarding the RTA, my lord, the information which he has received, my lord. Then your lordship kindly page 20, my lord.
Yes.
Regarding the resignation, my lord. Para 18, my lord.
Yes.
The review petitioner begs to state that the review petitioner had resigned from the membership of the Bharatiya Janata Party on 25/11/2021. The review petitioner on 25/11/2021 submitted his resignation letter from the membership of Bharatiya Janata Party before the President Atonam Booth Committee, Bangfor, under Swalkosi Mandal of Bharatiya Janata Party, and the President, Science Committee, Bharatiya Janata Party, Swalkosi Mandal, Atonam Bangfor, Gapanchayat, accepted resignation of the review petitioner and released the review petitioner from membership of Bharatiya Janata Party on 25/11/2021. Therefore, the review petitioner was not a member of Bharatiya Janata Party from so-and-so. The review petitioner could not annex the said resignation letter dated so-and-so in his affidavit in opposition filed in W so-and-so, as he misplaced the said resignation letter and could not produce the same before this honorable court during the proceeding of the writ petition. In the last week of October 2023, while searching some other documents in his personal file, the petitioner find out a resignation letter dated so-and-so, my lord. My lord, here is stated, my lord, while searching some other documents, my lord, even this is a complete negligence, my lord. He not search, he did not exercise
for
the,
this document.
yes, my lord. He did not exercise the due diligence. My lord, and my lord, he stated that he in her affidavit, it does not enclose, my lord. Even he has not stated about his resignation. Rather, he contested the case that because he resigned from the membership of the Gapanchayat member, it ought to have been a resignation from the political party, my lord, which your lordship has negated his assumption. And apart from this, my lord, page 20, also page 25, ground Z. He also stated, my lord, regarding this. Page 25.
Page 25, ground G.
Ground Z, my lord. Ground Z, my lord. Review petitioner had resigned from the membership of Bharatiya Janata Party and the President of Committee Bangfor under 12 case Mandal Bharatiya Janata Party duly accepted the resignation of review petitioner and released the review petitioner from the membership of the Bharatiya Janata Party with effect from so-and-so, and therefore the review petitioner was not a member of the Bharatiya Janata Party with effect from so-and-so. But the review petitioner could not annex the said resignation letter dated so-and-so in his affidavit in opposition in WCN so-and-so. As he misplaced the same and could not find out the same during the proceeding of the writ petition, my lord. The review petitioner could not annex the said resignation letter in his affidavit in opposition filed in session, as he misplaced the said resignation letter and could not produce the same before the honorable court, my lord. And my lord, in the last week of October, same, my lord. Here he has gone. He does not demonstrated that he had exercised diligence and searched this document, my lord. He has misplaced. Even if it was misplaced, my lord, he ought to have been stated in his affidavit, my lord. But this is complete and afterthought document, my lord. And apart from that, my lord, the RTA application, RTA reply, my lord, was received on 39/2023, my lord.
Even those marks.
Marks, my lord. That is within the limitation of the review application, my lord. He has not filed the review application. He waited, my lord. Here is the last week of October 2023. After
the judgment?
Not after over the limitation period, my lord, 30 days, my lord. He knows if I file along with this document, my revision. But this is a complete afterthought resignation letter, my lord. And my lord, regarding my lord, the limitation, my lord, I want to place my lord one judgment, my lord.
Recently, they're within the full bench, my lord. I think there it was 3 years delay. The review petition by the state lordship allowed. I raised this question which was rejected. Same point of limitation. That, my lord, Siksa Sarathi's case. So there, I was for the writ petitioner. I think there was a delay of 3 years. Lordship has condoned that delay. Said no, in a review petition doesn't like.
The cases were slightly, the fact is slightly different.
Slightly different. Same thing, my lord. This is also a writ petition, that is also a writ petition.
No, but
and that's a full bench judgment headed by your lordships.
Yes.
Yeah, my lord.
But this is, but Okay, this is,
This is
okay.
by two judges.
The two judge, my lord, this is in reference of the, my lord, the constitution base of the honorable apex court, my lord, paragraph 5, my lord.
Paragraph five.
Yes. My lord.
There,
Final 5, my lord.
paragraph five.
My lord, paragraph 5, my lord.
Yes.
The constitution bench in state of MP and another, Hilal Bhai, so had occasion to discuss the object and applicability of the prescribed periods of limitation as given by the Limitation Act. To a proceeding under 226 and conducted thus, it appears to us, however, that the maximum period fixed by the legislature as the time within which the relief by a suit in a civil court must be brought may ordinarily be taken to be a reasonable standard by which delay in seeking remedy under Article 26 can be measured. The court may consider the delay unreasonable even if it is less than the period of limitation prescribed for a civil action for remedy, but where the delay is more than this period, it will almost always be proper for the court to hold that it is unreasonable. The period of limitation prescribed for recovery of money paid by a mistake under the Limitation Act is 3 years from the date when the mistake is known. If the mistake was known in these cases, on or shortly after January, the delay in making this application should be considered unreasonable. If, on the other hand, as Mr. Ellis seems to argue that the mistake was discovered months later, this would be a controversial fact which cannot be conveniently be decided in writ proceedings. In either view of the matter, we are of the opinion the orders of the refund made by the High Court in these 7 cases cannot be sustained. The decision in Hilal Valley Supra was as regards recovery of money, the principle enunciated therein would apply to issuance of writs by the High Court in every exercise of its power under Article 226. In the fact of the decision in Hilal Valley Supra, there can be no escape from the conclusion that the High Court's jurisdiction is not barred in considering an application for review of an order passed by it under Article 226, even if the application seeking review of the order is made beyond the prescribed period of 30 days from the date of making the order. When the High Court entertains an application for review, even after expiry of a period of 30 days, the High Court, as a measure of public policy, must be satisfied that there were reasons preventing the applicant from making an application for review for reasons beyond his control. It is therefore imperative that an application seeking review of an order made under Article 226 discloses adequate reasons. If the application is not made expeditiously, if an application for review is found by the High Court to be suffering from negligence or losses, the High Court may not entertain such an application for review in respect of an order passed by it even under Article 226. So the Guwahati High Court rules as correctly indicated in Sri Kanak Chandra Sharma Supra do not prescribe any period of limitation for making an application for review of order passed in a writ proceedings. The High Court may, in a given case, decline to entertain an application for review of an order passed under Article 226 if the application for review is inordinately delayed and in the meanwhile the lease becomes a stall. There can be no doubt that the High Court, as a court of plenary jurisdiction, can review its own order passed under Article 226 at any given period of time. The High Court would nevertheless ordinarily govern itself by the established standards.
Okay, that's all.
My lord. So there is
So the High Court can.
Can, my lord, can.
So there's no bar.
There is no bar. But if the High Court satisfied, my lord, the reason given by the in the review application, there is no statement regarding the delay, my lord. Even they have not filed a separate application for condonation of the delay, my lord. If there is also any reason, my lord, given for the delay, my lord.
Okay. That's all.
Yes. My lord, I said I did not complete, my lord. My learned friend did not deal with the main point. Now please come to me, lord, the judgment once. The judgment is at page 168, 154. That was one ground, and the other ground on which your lordship interfered. Please come to page 163, my lord. Para 18 and 19, the other ground. The final evaluation sheet shows that no marks were allotted to the petitioner for being a member of the family of Gaon Pradhan, though he was son of earlier Gaon Pradhan. No marks were allotted to the petitioner in terms of the view of the Mojadar, though the Mojadar had issued certificate dated 21/12/21, stating that petitioner had a good moral character, besides having experience of duties and responsibilities of Gaon Pradhan. To sum it up, the question raised in the writ petition are decided as follows. The question whether respondent number 8 is a resident of Khanpara Parbat village is a disputed question of fact which cannot be decided in this writ petition in view of different documents taking contrasting stand in respect of the same issue. The petitioner being the son of an earlier Gaon Pradhan, and as the view of the Mojadar had been taken as reflected in Mojadar letter dated so and so, the state respondents were bound to consider giving some marks to the petitioner out of 10 marks allotted in terms of the clause G of the advertisement dated so and so at the time of interview. With regard to the clause in the advertisement which says preference should be given to a member of a family of Gambura, this court is also of the view that question of preference can only be applied when there are more or less or more successful having same marks. However, in this case, the petitioner secured lesser
Two or more. Two or more.
I'm sorry, but yes. Further, this court in case of so-and-so had my lord, two grounds were asked by the petitioner, my lord. Number one, he belongs to a Gambura family. Therefore, there is a column of 10 marks. So he should have been given. And secondly, I belong to a political party. Therefore, I ought not to have been selected. Now, my lord, kindly come to your lordship's finding. At page para 29. I'll come with the delay and all, my lord. The document shows that respondent number 8 had not resigned from the political party he belonged to at the time of his selection as Gaon Pradhan. He having only resigned from membership of the Gaon Panchayat. As such, the respondent number 8 was ineligible to be considered for selection and appointment to the post of Gaon Pradhan. Further, petitioner being a son of an earlier Gaon Pradhan and Mojadar having given his view, it was incumbent on the state respondents to have considered giving marks to the petitioner at the time of interview in terms of clause Z of the advertisement dated so and so. As the petitioner and respondent were the only two candidates in the fray for selection and appointment to the post of so and so, and as respondent number 8 is found to be ineligible to have participated in the selection process, selection of respondent number 8 is Gaon Pradhan by impugn is being is hereby set aside. Respondent number 4 is directed to issue necessary order for selection and appointment of the petitioner, etc., etc. Now, the Lord will kindly come to your lordship also went by the view that no marks were given. You were given marks, my lord. Please come to page 171. I think now this document was before this honorable court, page 171. Kindly see, my lord. Keshav Chandra Boisya is the writ petitioner whom my learned friend represents. And from this, my lord, it appears as if no marks were given for that on account of my lord he belonging to family. So, my lord, this is the final sheet. This is the final sheet, my lord. So he got 27.33, I got 30. Am I clear, my lord? Page 171.
Yes.
Final evaluation sheet of candidates for the post of so-and-so. Now, going by this, lordships carry the impression that 10 marks which he ought to have got as belonging to the member was not given. No, it was given by all the three members. Page
Also, my signature.
172, 173, and 174.
Yes.
Kindly see, my lord. Gambura family member, Mojadar view, 10 marks. I was given 0. Am I clear, my lord? 172. Marks obtained. First is personality, ability to inspire people, 10 marks. Leadership and attitude skill, 10 marks. Gambura family member, Mojadar, 10 marks. Has your lordship got it, my lord? No, general knowledge, total 45. Kindly see, he was given 10 out of 10. I was given 0 by one member. Then please come to page 173. Similarly, he was given 10 marks. I was given 0. Now, Lordship will kindly come to page 174. 10 marks, 0. So, Lordships proceeded on the basis that this 10 mark was not given to him. No, it was given. So, my Lord, High Court is in court of record. And to correct an error, my Lord, there is no limitation is prescribed. My Lord, my learned friend has referred to that Bhai Bhai's case. My Lord, consistently the Constitution bench of the Supreme Court has said, in a 226 proceeding, Limitation Act do not apply.
Okay, who is holding the post of governor?
I'm assuming.
Nobody. Now, my lord, because of the contempt proceeding, my lord, I have been
given
on 6/6/2024.
No, my lord, therefore,
yes.
So you are holding, so it's okay.
Now, my lord, the issue is he was given 10 marks, whereas Lordship took the view he was not given. So there is an error apparent on the face of the.
Well, first of all,
yes,
this document was not before us.
Which one, my lord?
This 172, 173, and 174.
No, it was not because there's nobody has Lordship. My lord, our specific ground is going by 171. Lordship carried that impression. Lordship did not call for the record. That is a specific ground. Kindly see, my lord. Para 17. These are specific case. Page 18 of the review petition. Last two sentences at page 18. That the review petitioner begs to state that while passing the judgment and order dated 26/9/23 in WPC number so and so, Honorable Court came to an erroneous finding without calling for records of selection as regards non-allotment of marks to the respondent writ petition in terms of clause G of the so and so. The review petitioner obtained final evaluation sheet of candidates for the post of Gram Pradhan under Hazur Revenue Circle and evaluation sheet 3 numbers of selection board through RTA application. Final evaluation sheet of candidate for the post clearly reveals that each of the 3 members of the selection board had allotted 10 marks to the respondent writ petitioner under the column Gambura family members, whereas under the said column of Gambura family, no mark had been allotted to the review petitioner. So it's an error apparent on the face of the records. So to correct this error, my lord, Supreme Court says no limitation is prescribed. And my lord, review is under 226 itself. A review of a 226 petition is again under 226, the Ramarao's case 1963. Then my lord, in Motichan, Motichan and Ramchandra Devdhar, both Constitution bench judgment, Supreme Court has said, my lord, review limitation act does not apply to 226%. And in that case, full bench judgment, my lord, where I think there was 3 years delay. Where Lordship has, I mean, in spite of that, review was entertained and review was allowed. So, my lord, there were 2 bases for the judgment. Even if your lordship disregards the second the ground of that certificate, but on the first ground, the judgment needs to be reviewed. So he cannot be selected.
No, but on the second ground, you
Suppose,
can.
no, I'm just making a submission, my lord. Supposing your lordship is not inclined to accept that point, I'm just making this submission. Then that other point is there. How can he be selected?
No.
Lordship has given a direction that he should now be selected.
No. The thing is that supposing he has been given marks, but you cannot be considered because of that political party.
But my ground of interference was 2. Ground of interference was not giving marks and I not being it. Para 29, Para 29 of your lordship judgment at page 168. The documents show that respondent, no, that's not it. Further, from the 5th line, petitioner being son of the earlier Gaon Pradhan and Mojarar having given his view, it was incumbent on the state respondent to have considered giving marks to the petitioner at the time of interview in terms of so and so. So lordship proceeded on the basis that no mark was given. And my learned friend, in spite of getting the review petition, he did not argue on that point.
Yes, what do you say about the marks? Only about the marks.
Madam, I've already indicated the signature, madam. And
Signature, yes,
yeah,
signature.
apart from that, madam, I have issued a question on the maintainability, madam. First, madam, this document this review application has been filed on the basis of these two documents. Madam. First, they have to pass the first condition. I have submitted that.
Correct, the BJP, the political party.
No, political party and also this marks document, madam. The test, my lord, they have to show the.
Lordship will call for the records.
No, just don't let me see.
My lord, they first have to show that they have exercised their due diligence, my lord. But my lord, on merit, this is the merit, my lord. On marks, that is the merit, my lord. Even if the judgment is erroneous on merit, my lord, that cannot be a ground for review, my lord. The scope of review is very limited, my lord.
Okay, there is one thing. This signature, none of them matches.
There are three different members. How will it match?
No, please look.
No, my lord, that's why I said if these are four documents, send my client.
No, none
Please
of that.
call for the records and find out, my lord.
Please look at it. Please look at it.
My lord, I go by what my instructing counsel says, my lord. I will produce this original, my lord.
No, please look at it.
Yes.
With
Page
the
number,
naked
my
eye,
lord.
what does it look like?
Page number, my lord.
Page 171,
Yes.
172, 173, 174.
Yes.
Now 171, we have got those three pair signatures. Now you look at 172. 172 matches which signature in 172?
172 matches with the first signature. Naked eye, my lord. Then, my lord, page 173 matches with second signature. Then, my lord, 174 matches with third signature. If my learned friend has become, my lord, forensic expert, I don't know what prima
Look,
facie-
even for the naked eye. Come on,
Naked eye, my lord. I'm
you have
saying
got
so.
to be fair. It doesn't look at all like it.
No, it looks like, my lord.
No.
Even my eyesight is not that bad, but I find, my lord, it tallies. Page 172 tallies with first signature.
Okay, what about 173?
Yes, 173 tallies with, my lord, second signature.
Are you sure?
Second.
No. It does not at all. Please look
It
at
does, my lord.
No.
It does.
Okay, if that's the
It does.
case, okay.
Then 174 tallies with, my lord, third.
Okay. Heard. Mr. K.N. Chaudhary, Learned Senior Counsel for the review petitioner. Also heard Mr. S.K. Roy, Learned Counsel for the respondent
One, madam.
number one.
With the lordship's kind permission, can I take it?
The petitioner, the review petitioner has put to challenge the impugned judgment and order dated 26/9/2023, passed in WPC 4451/2022, by which this court has held that the selection and appointment of the review petitioner as to the post of Gaon Pradhan of Sanpara Parbat village what have I said? By which this court has set aside the appointment of the review petitioner to the post of Gaon Pradhan of Sanpara Parbat village, as he was found ineligible to have participated in the selection process. Due to the review in the full stop. Further, this court also had found that the respondent number one slash writ petitioner, who was the son of the earlier Gaon Pradhan. It was the state respondents had not given marks to the respondent number 1 slash writ petitioner at the time of interview in terms of clause G of the advertisement dated 1/12/2021. Next para. The facts of the case in brief is that the respondent, no, the review petitioner and the respondent number 1 slash writ petitioner had participated in the selection process for appointment as Gaon Pradhan. The review petitioner had been selected as Gaon Pradhan of Sanpara Parbat village on culmination of the selection process. The respondent number 1 slash writ the respondent number 1 slash writ petitioner made a challenge to the appointment of the to a review petitioner on the ground that the respondent number 8, the review petitioner, being a member of a political party at the time of his selection as Gaon Pradhan, could not have been selected in terms of the terms and conditions stipulated in the
Clause C under clause 3,
where?
page 36. Page 36.
Under clause
Eligibility criteria C, then subclause 3.
under clause C bracket 3 of the advertisement. The petitioner had also the respondent number 1 had also taken a stand that the respondent number 1 should have been awarded marks being a family member of the Gaon Pradhan in terms of clause G of the advertisement dated 1/12/2021, which was not done. The other grounds taken in the writ petition by the respondent number 1 for in challenging the selection of the respondent number selection of the review petitioner was that the respondent number the review petitioner was not a resident of Sanpara Parbat village and that preference was to be given to the family member of a Gaon Pradhan for appointment to the post of Gaon Pradhan. Next paragraph. This court, by judgment and order.
So, my lord, eligibility.
I've already said political party. This court, by judgment and order dated 26/9/23, passed in WPC 4451/2022. Held that the petitioner, held that the respondent number 1 being the son of the earlier Gaon Pradhan and the Mawzadar having given his view, it was incumbent on the state respondents to have considered giving marks to the petitioner at the time of interview in terms of clause G of the advertisement. Full stop. Further, no. Further, as the review petitioner was found to have resigned from the membership of the Gaon Panchayat only, and as he had not resigned from the political party he belonged to at the time of his selection as the Gaon Pradhan, the selection of the review petitioner as Gaon Pradhan was set aside. Full stop. Next paragraph. Mr. K. N. Chowdhury, the learned senior counsel for the review petitioner, submits that the review petitioner had resigned from the political party by letter dated 25/11/2021, and the review petitioner had been released from the primary membership of the said political party by letter dated 25/11, on 25/11/2021. However, the review petitioner could not produce the said document at the time of disposal of the writ petition, as he had misplaced the said letter. It was only in the last week of October 2023 that the review petitioner found the said resignation letter dated 25/11/2021, while searching for some other documents in his personal file. Next paragraph. The learned senior counsel for the review petitioner further submits that as per the information provided to the petitioner by letter dated 30/9/23 and the annexures
1711.
And the annexures therein by the additional district commissioner Kamrup in reply to the information sought for by the review petitioner under the RTI Act, 2005. The evaluation sheet the final evaluation sheet signed by all the three, what is this? All the three
Member of selection.
member of the selection committee and the evaluation sheets made by the individual members of the selection committee showed that the respondent number 1/writ petitioner had been allotted 10 out of 10 marks by all of them for being a family member of the Gaonpura. Next paragraph. The review petitioners counsel submits that as the said documents which are now, which the said documents referred to above could not be produced before this court at the time of disposal of the writ petition, comma. An injustice has been caused to the petitioner, to the review petitioner, comma, which can be rectified by way of the review petition. That's, he submits that in view of the above documents which have been produced by way of the review petition, the impugned judgment and order dated 26/9/23 passed in WPC 4451 of 2022 should be set aside. Correct?
Yes.
Yes, referred to some judgment also. What is the judgment referred to?
I have that.
Huh? Nothing, no? Okay, next. Mr.
SK.
S.K. Roy, the learned counsel for the respondent number 1 / review petitioner submits. Writ petitioner submits that the review petition should be dismissed as the review petitioner has never made any averment in his affidavit filed in the writ petition, filed in the writ petition that he had resigned from the primary membership of the political party, wide letter dated 25/11/2021. Further, there is no averment made by the review petitioner in the present review petition that the resignation letter dated 25/11/2021 had discovered a new and important matter or evidence, after the exercise of due diligence, which was not within the applicant's knowledge or could not be produced by the applicant at the time of disposal of the writ petition. He submits that the resignation letter dated 25/11/2021 is a personal letter written by the review petitioner, and the review petitioner cannot take a stand that it was not cannot take a stand other than that which is provided for under the provisions of the CPC. He also submits that in terms of the judgment of the Supreme Court in the case of S. Tirupati Rao versus M. Lingamaya and others, 2024 7 SCR 1077. Though the provisions of the CPC would not apply to proceedings under Article 226 of the Constitution, there is authority in abundance that the principles flowing from the CPC may be safely taken as a guide to decide writ proceedings. He submits that the production of the resignation letter dated 25/11/2021 for the first time in this review petition appears to be an afterthought. He also submits that there is no averment made by the review petitioner that the review petitioner had exercised no, that after exercise of due diligence by the review petitioner. Oh no, what did you say that about the due diligence? What have I said? He also submits that the review petitioner has not taken a stand that the resignation letter dated 25/11/2021 could not be produced after the exercise of due diligence or that it was not within the applicant's knowledge. Pusta. He also submits that there has been no discovery of new evidence for which he had no prior knowledge, or that it could not be produced at the time when the writ petition was disposed of. Next paragraph. The counsel for the respondent number 1 / writ petitioner has also submitted that a perusal of the final evaluation sheet of the candidates, which has been signed by 3 members of the selection committee, when compared to the signatures of the individual evaluation sheets. No. But just read it again. It's wrong. Perusal of the submits that the examination of a cursory examination of the signatures of the 3-member selection committee in the final evaluation sheet of the candidates vis-a-vis their signatures in the individual evaluation sheets of the members of the evaluation committee, selection committee, shows that the signatures are not similar. He accordingly submits that the documents seem to be fabricated. Correct?
Also, my lord, under RTI Act, my lord, section 8G, my lord, it cannot be disclosed.
What cannot be disclosed? He also submits that the mark sheet, that the evaluation sheet of the individual examiners, all the final also. Final cannot be.
Final can be, but
Submits that the individual evaluation sheets made by the individual members of the selection committee cannot be furnished to the candidates.
RTI application.
Cannot be furnished under
RTI application.
and which provision?
Section 8.
Under
Clause G.
section 8
Clause G.
brackets G of the RTI Act 2005. He also submits that there has been no reasons given by the review petitioner for the delay in filing the review petition.
And also when he filed the RTA application.
But he also submits that there is nothing stated by the review petitioner as to when he filed the application under the RTI Act. On the basis of which the evaluation sheets have been furnished to the review petition. He accordingly submits that the review petition should be dismissed. I have heard the counsels for the parties. Okay, we'll make it CAB for the time. Take time. No time. Acha, Mr. K. Chowdhury, assisted by Mr. R. Sharma. Huh?
42. May I please, your lordship, my lord, this contempt petition has been filed for violation of the direction passed by
Just a minute, just a minute. Yes.
My lord, or your lordship's order at page 12, my lord, the relevant portion is at page 15, my lord. There are 10, 11, 12, my lord.
So the application was to be decided.
Yes, my lord. My lord, para 11, my lord, accordingly, the respondent number it shall submit an application seeking approval of the government for running the so-and-so market addressed to the so-and-so who shall take a decision on the respondent 8th application within a period of 3 weeks. So that has, and till such decision, my lord, the market of the respondent number, it was allowed to continue. Till such a decision is taken, till then only respondent number H market was allowed to continue. In paragraph 10, my lord, the secretary of the has issued however, the respondent number has not made any application to the government seeks approval for running the private market. Accordingly, this court is of the view that unless and until the respondent number 8 gets the approval for running the private market under section 107 of the 1994 Act from the government, the petitioner would be ineligible to run the market. Unless and until they get the approval, they are ineligible. However, keeping in view the fact that the respondent number it has been running the private market for a long time, some time should be provided to the respondent number 8 to seek approval for running the market. Accordingly, the respondent number 8 shall submit an application seeking approval, and the authorities were to decide within a period of 3 weeks time. So your lordship was of the view that unless and until there is a approval, they cannot run the market. But considering they are long, because it was running for a long time, your lordship granted, allowed them to run the market till a decision is taken. But till now, the decision has not been taken, my lord.
Yes, Mr. Datta.
Yes, sir. I have, lordship, may kindly, where is my affidavit, my lord? I have filed my. My lord, before that, my lord, I want to make submission on.
There is another writ petition which says that government should not interfere.
That is also there. My lord,
And that writ petition, that order was a part of the pleading in my writ petition. Your lordship considered that. In my writ petition, we annexed that order also, and your lordship considered that.
Because of that order, we are not giving. We are not saying that, my lord. First thing, my lord, writ petitioner, my lord. Writ petitioner filed the writ petition, my lord, challenging the private respondents market, my lord, because that was a private market. It's running from since long, my lord. What happened, my lord, after 107, my lord, enactment of amendment of 107, lordship had passed this order, my lord, so that through 107, the private respondent, my lord, not petitioner, he will apply for the NOC and government will consider, my lord. Thereafter, accordingly, after lordship's order, my lord, he applied. My lordship may kindly see my page number 24. I've stated, my lord. Paragraph 5, my lord. May I read, my lord?
Yes.
the seventh line, my lord, starts from, it may be mentioned that
Yes,
it may be mentioned that the petitioner in WBC so and so, the present petitioner also submitted an application to the department requesting not to grant permission to Bagbar Bazar Market Committee to run the private cattle market. After filing of application, the petitioner, he filed application so that not to consider. The intention of the petitioner may be seen, my lord.
That is true, my lord.
Let me come in.
Even in our petition,
My
that
lord,
was our prayer.
thereafter, my lord, what happened, my lord? Next paragraph, my lord. Both the representations were thoroughly examined in the department. The section 107 of the Assam Panchayat Act 1994 was amended by the Assam Panchayat Amendment Act 2023. As the corresponding financial rules were being framed, it was duly communicated to the petitioner as well as the secretary of so-and-so market by letter dated 12/8/2024 that the department would be able to take a decision on the matter only after the enforcement of the financial rules. And for that paragraph 8, my lord, the rule is already almost ready, my lord, and it will be placed before the honorable cabinet very shortly, my lord. Only after the framing of rules, my lord, we can consider their prayers rightly, my lord. It was informed, my lord, and this is a contempt proceeding, lord. She will see, my lord, whether any willful violation is there or not, my lord.
Obviously,
At
my
this
lord,
stage,
it
my
is
lord,
there.
petitioner is nothing, my lord, because petitioners, my lord,
what is he doing now?
No, my lord, nothing.
What is your thing?
No legal grievance, my lord. No legal grievance. At that time, he was running the government.
Okay, now he's not running.
No, my lord.
But my lord, the violation of this order is there, my lord.
But it is not your concern. It
Yes,
is between
it's
me
not
and
his
him.
concern.
It's
Yes,
not between you and
Yes, my
anybody.
lord.
It's not, you've got nothing to do.
Yes, my lord.
But at that time of filing the contempt.
Maybe, but now it's gone. Now your right is gone.
Yes, my lord.
Now it's only
cannot
been,
insist.
at the time of filing in a contempt case, the only thing you've got to do is you've got to bring it to the notice of the court.
Yes.
Yes, my lord.
Then your
Yes,
job
my
is
lord, that
finished.
true.
Yes.
Your job is finished.
Even, my lord, appeal.
So now let me decide
Yes, my
whether,
lord. Yes, that is true, my lord.
so Mr. S. Datta, learned counsel for the petition, for the respondent number,
My lord, respondent 1, my lord.
respondent number 1 submits that the respondent number 8 in the writ petition had submitted an application to consider for getting approval, application to get the approval for running the private market.
Yes.
Under section 107
Yes.
of the
Assam Panchayat Act
Assam Panchayat Act
1994.
1994. At the same time, the respondent, the petitioner hearing had also submitted a representation not to grant approval to the respondent number 8 therein.
Yes.
Mr. S. Datta submits that the petitioner has got no role to play as on date, as the settlement of the market with the petitioner has expired.
Yes.
A settlement period of the market has expired. He also submits that to decide the issue with regard to granting of approval of private markets by the government, financial rules are being framed. And some more time is required for the state government to take a final decision on the matter. To stop. In view of the submission made by Mr. S. Datta, this is the matter. After
2 months.
After 2 months.
Highly obliged.
My lord, this case, I'll pray for an accommodation.
My lord, this IA has been filed by the ONGC for getting the interim order vacated. And my lord, there's also an order by your lordship to consider the entire issue.
No, instead of my lord, lordship will have it on the reopening, my lord will take on 8th of January.
6th in January.
Okay, 6th.
6 is Monday.
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 Or seventh, my lord. Seventh is it?
Let it be on, if it is not inconvenient to my learned friend, on 8th
Again,
or 9th.
9th were fixed already.
let it be on sixth, my lord.
Maybe all were fixed, 6, 7, 8, 9 were fixed already.
There is some
On the
urgency
prayer
on
of
our
the,
part
on the
also.
prayer of the party list the matter on 6.
6th.
Not 6,
Interim to,
not 6, not 6.
let
6
it
is
be
Monday.
8th, my lord. Let it be 8th.
Why not on a Tuesday?
Okay,
or
okay, well, I'm
Thursday?
agreeable, my lord. Only 7th I have difficulty.
7th.
7th I have some difficulty. 9th,
9th,
9th is a Thursday.
9th we are fixed. We are fixed. Some item we have
It
already.
will not take a very long time. This is
No,
not-
no.
Oh, other matters.
The
are-
other matter will take long.
Or
Okay,
it is-
we'll find 8th, but.
8th.
Or why not after that? There are so many we have.
Or let it be on 7th, my lord. Tuesday. Well, interim order to continue till.
Interim order to continue till the next.
My lord, I am representing ONGC in this matter, my lord.
Mr.
S. Chakrabarti.
S. Chakrabarti appears for the
Respondent, applicant,
respondent.
applicants in the I.
And just say Mr. K. Chaudhary appears for the writ petitioner, while Mr. S. Chakrabarti appears for the respondent number 2 to 5.
For us, it makes no difference.
I know he wants his name.
For us, for me,
Yeah,
it's a
of course, of
difference.
course.
Makes a difference.
Everything.
44. Yes, my lord. My lord, Deputy Commissioner Office has informed that, my lord, some time is required for negotiation, my lord.
Till now, I have not been called for
Huh?
till now, the petitioner has not been called for any negotiation.
Call him.
Yes, my lord, they
You
are
have
saying
asked to
that,
file
my
a
lord,
report to them.
they are trying to, my lord, settle the matter for negotiation, my lord.
Mr.
M. Chetia.
M. Chetia, learned counsel for the
Yes, phone number, my lord, 6, 7, my lord,
6 and 7.
and 1, my lord.
1, 6 and 7 submits that he has been given information that he has been informed that an out of court settlement is being attempted by the district commissioner.
Yes.
Mr.
R. Sekhar.
R. Shekhar, learned counsel for the petitioner, submits that he has not been given any information by any of the respondents for attempting an out of court settlement. Madam?
Yes, your lordship, I'm appearing for 2, 3, 4, and 5, that is Assam tourism. Your lordship, we also want this thing to be resolved because we are also losing a lot of revenue in
Miss
this. P. Barua, lordship.
T. Barwa appearing for the respondents number 2 to 5 submits that the respondents 2 to 5 wants a quick resolution to the dispute as they are losing a lot of revenue.
Revenue, yes.
Mr. M. Chetia shall on the next day inform this court as to why the district commissioner has not called the petitioner for a settlement, if the same is to be attempted by the district commissioner. Out of court settlement, huh? So you tell him that this is the same. That way maybe they can start doing something.
In the meantime, the ATDCL has filed an additional affidavit, and in that additional affidavit, it is very clear that how the fund has been obtained
Okay, yes, your lordship.
and for construction of that wall and boundary.
List the matter on when?
Second week of March.
Second week, yes. What, the 22nd is. No,
Let it
first.
be on first week, on 10th.
10th.
Much obliged.
Supplementary orders 52.
Where is the
report? The committee and the report hasn't found that he has done the work. It hasn't found my lord.
They done the work.
Done the work and the supply, not work, but supply has been done. And my lord, we will be in the last part, my lord, that will petitions, my lord. In the, as per terms, only the bill will be calculated and then provided.
So you make you tell us what is the amount payable to him?
No, the amount is equal to him, and only thing is that when paragraph number 3, my lord, the committee had decided to approve the rate seen in the bill. I was considering the cost of one.
You see, whatever it is, you see, we want, you see, I cannot close the writ petition like this. It'll never end. Now, the thing is that you have to decide as to how much is to be paid to the petitioner. He's claimed how much?
11.41817116.
Yeah, so you make, okay, right.
Lordship will, that paragraph number 3, my lord. In paragraph, there are some, they are saying that there will be some negotiation between them, my lord. So
That is why.
That is because 85,000, 110, 85,190.
You see, it says the authority shall be at liberty to invoke mediation process.
Lordship.
You have got no liberty. There is a direction of this court. Please tell your clients, there is no question of liberty. Now you have taken a decision that yes, he has done the work. Now you decide how much is to be paid to him. You can do whatever you like. Mediation meaning you can talk to him, have some negotiation, that's all, if you want. But that is not the direction of this court. Direction of this court is you decide how much is payable to him, that's all.
Lordship will fix it after 3 weeks, in the meantime.
Okay. Right, Mr. S. Bora, learned counsel for the respondent number 2 has submitted the meeting minutes of the inquiry committee held on, dated 12/12/2024. Wherein the BTC has admitted to the fact that the supplies had been made by the petitioner. Have been made by the petitioner. In view of the above meeting minutes dated 12/12/2024, the BTC authority. No, Mr. S. Bora shall obtain instructions as to the amount payable to the petitioner. Mr. S. Bora submits that he needs 3 weeks' time to obtain instructions on that count. Accordingly, list this matter on. You want, you can take a photocopy of this also.
I'm handing about it.
Oh, he needs that to show his client something is happening.
Production list for motion item 1.
No, before my planet fan starts, man. In this case, there is an instruction for the AG to appear in this case, man. Let it be taken up tomorrow as a first item.
What is this matter?
Apply, this is challenging a tender process, man. Advocate General has been instructed to appear. It has moved unlisted today, my lord, then copy was communicated to the AG.
No, let us hear a little bit. We won't pass any order, let us hear. So that at least we'll have some idea what he wants. Yes, what is your case?
Mission Director of Sub 6 has invited an NIT. Lordship will find the NIT at page 30.
Page 30.
Lordship, annexure 3.
Annexure 3, page 30, yes.
As per NIT, Lordship, this is regarding supply of school uniform to the secondary level. Lordship will find at page 31. When
is the last date of submission of tender?
29. Tomorrow.
Tomorrow. Why did you come today?
Lordship, yeah, we have a pre-bid meeting was held on. We have filed requisition that these plots should be.
When was pre-bid meeting held?
Pre-bid meeting was held
9/12.
9/12.
9/12. 9/12. And today is 18th.
Pre-meeting is for 9/12. We have immediately filed representation They
Huh?
issued,
After pre-bid meeting,
they have issued corrigendum. After Lordship, we have filed application to the authorities. We have had 2 corrigendum amending the petition. Today also they have issued a corrigendum, but they have not considered our case. That is why we have to approach the Honorable Court. They assured us they will modify. Because they want to accommodate some big companies. Lordship will already, this judgment has been passed by the
and you are a small company.
No, not small companies, not Lordship. Lordship will, what they have decided. They want to accommodate some companies. That is why I inserted the clause page 31.
You are challenging the clause.
Not the clause. The discrimination on the ground.
No, are you allowed to participate?
No.
Oh, you cannot participate.
Because Lordship, as per the memorandum of understanding and the rules framed under the Charbot 6 manual of purchasing the goods, it should be through the school management committee, SMDC, not a bulk quantity they could purchase. And they cannot, community participation is very much necessary. And this regard already there is a case, and already this case is decided by this Honorable Court. Earlier occasion also they have invited same process, and this court held that it should be participated through SMDC as per manual of purchase. Already covered. Lordship will kindly see page 31 again.
Yes.
Mission Director Sarbochiksa Assam Kahilipara Guwahati Assam invites bees from textile and garment manufacturer having their own in-house facility for spinning, weaving, resisting, and stitching standard in India under the PAN-card. Lordship, neither in Assam nor in the neighboring state, there is none to participate in tender process. It is for a particular group of companies only. And as per Lordship, the manual of purchase, that is page 50. Manual of procurement.
Yes.
Lordship will page 49 onwards.
My God, what is this? This is thicker than the writ petition. Who has given this?
Lordship, we have not annexed the manual, total manual. Manual is a big paper. That is why it is a notified big manual. We have given a copy, Lordship.
Why don't you make it part of the writ petition?
We have made it part. Only the relevant manual we have not annexed.
Why do you have to give me if it's not required? How? Just a minute.
It is a notified manual. That is why, Lordship, we have annexed the relevant portion. That is why we have given the copy, Lordship.
Yes, what is your case?
Page 49.
Yes.
The manual of financial management and procurement for the scheme of Samagra Shiksha. Last portion will find the provision of the manual would be mandatory. Lordship got it. Last provision of the manual is mandatory. As per manual, they have to purchase the uniform, specifically considering the size of the student and everything through the SMDC, School Management Committee. And they want to purchase in bulk quantity from huge industries. They own not a single person from the earlier participant, they cannot participate in that process. Only to accommodate some person, they are deciding all these things. Already there is a case in regarding this matter. Earlier also they have done the same thing. And already same thing was challenged by before this Honorable Court. And this court set aside the order. And Lordship will find page 64 is the order.
Yes.
Lordship will find guideline has been issued. Page 80. In view of the discussion above, this page 80.
Yes.
Before that, Lordship kindly see what I have stated, page 72.
Yes.
The basic condition of the petitioner is that there is not a single textile mill in manufacturer of garments in the entire Northeast India that would meet the above eligibility criteria. Therefore, it is apparent that the aforementioned eligibility condition has been incorporated with malafide intention to exclude local entrepreneurs like petitioners. Moreover, impugn eligibility condition restricts community participation and therefore contravenes the guideline in FMP, financial management rules. And that is why finally Lordship is 80. Para 51.
Page 80, yes.
Para 51.
Yes.
In view of the discussion made above, this court is considered opinion that the impugned eligibility criteria contain EOI and the facts and circumstances of the case is arbitrary, hence not sustainable. Having held the above, court would be ordinarily gone to the strike down the EOI. However, having regard to the mandate of clause 7.4 and clause 7.7 of FMP, FMP is a finance management regulation, and keeping in mind the interest of the school student, balance of equities, these petitions are disposed of with the following observation and direction. These are the observation. Respondent may prepare panel of vendors for supply of the school uniform as per impugned EOI, but operation of the panel shall be kept confined only those individual supply orders net value exceeding 25 lakhs. Panel is prepared shall remain valid for only period of 1 year from the date of notification. For supply order valued above 25 lakhs, principal and procedure laid down in 7.7 EMP and GFR 2007 shall be followed. Matter of procurement of school uniform, respondent number 1, 2, 3 shall not in any manner encroach upon the autonomy vested upon the respective SMC and the Act of 2009 and rules framed thereon. So in this particular case also same thing has been again they have done. And secondly, Lordship, they want this EOI in the website of Lordship will find it was published in Assam Tenders Government in. But government has already notified an office memorandum that can be published in the G portal, GM portal. And GM portal provide.
Why is this, Mr. Counsel? Half your papers are outside. This is
No,
the first
today,
day.
it was, I have got just now, Lordship. That is why I have to, just now I have got it. Just now I have got it. Just now I have got it. It was notified on January 2024. Just now I have got it. Government e-marketing GM is mandatory for all procuring entitled procurement of all goods services that are available in GM as per Assam Public Service Procurement Rules 2010. So GM includes procurement of the clothes. And GM, they cannot include the condition that it will be participated by the manufacturer of weaving mills and the composite mills. Everything has been violated. Only to exclude the local entrepreneur. Already, Lordship, last total years from the constitution of the Lordship, the Sarva Shiksha Vision, these local entrepreneurs are supplying the clothes. Because you have to measure the students' size and save everything. And thereafter, they have to manufacture the clothes. And now they want to accommodate some huge companies only of their favor.
Public interest is involved. Apply public interest is the supply of all this. My lord, Lordship will fix it tomorrow, my lord.
There is already a stay order. There is already an order.
It is whatever passed before the AG, my lord, because AG has, before the Advocate General.
So what? Just because AG will come, it will be a different order. It will somehow magically turn into a different order.
Will take the first item tomorrow, my lord. Because the government has given the instruction to AG to appear. No, as a first item, my lord. As a first item. As a first item, my lord, Lordship will take, my lord.
I've got a flight to catch.
Lordship may fix this matter in the January. Till then, it should not finalize.
My lord,
nothing will happen.
We'll listen on Friday.
Lordship, that can be done, my lord.
Let it be listened till Friday. It will be status quo.
Status quo. Till Friday.
Till Friday.
That will. Tomorrow, my lord, it has been. Hardly will take only 5 minutes, my lord.
Mr. Counsel, I've been doing these cases for some time, I know. Look, it's not that I am running.
No, no,
The
no,
problem
that's
is,
it, that's right.
the
Right,
problem
right.
is, and I have got a lot of matters.
Lordship will not pass any order, my lord. Tomorrow is the date, my lord. Tomorrow is the date.
Can we list it before
Before
the
any other
bench?
bench, my lord. Tomorrow. That can be done, my lord.
We can list it before the other bench.
Lordship.
Lordship, 2 p.m. it will be open, Lordship. 2 p.m. it will
2
be open, Lordship. It will be, today also we have tried basing the 2 p.m. Lordship. It is not reached. Now, Lordship, 4, almost 4. Tomorrow it will happen, Lordship.
Any other bench, my lord.
That
We'll
will
mention
be
it as
open,
a facility, my lord. We'll
because
take it.
motion item are there. Today, will be, tomorrow is motion item only. So I mean, it may not reach also before 2 p.m. On Friday, it will-
This is Bharwar pages. You mentioned it before Justice Bharwar. We'll have it there listed before Justice Bharwar. Yeah, I'll pass an order. Right. Heard Mr. S.K. Goswami, learned counsel for the petition, who submits that the last date of submission of the bids in terms of the NIT is on 19/12/2024. He also submits that the manner in which the respondents are seeking to issue supply orders is in violation of the judgment and order dated 13/12/2019.
as well as manual of
Passed in WPC 1984/2019. Read with which manner?
manual of financial management procurement for Thermosexa.
And in terms of manual of financial management and procurement, bracket FMP, for scheme of Samagra Shiksha. Then what about this?
Lordship, this is yesterday it has been issued notification. That is why, Lordship.
So according to this, procurement has to be done through GEM.
Not this e-portal.
So he also submits that in terms of the OM dated January 24, issued by the government of Assam Finance Department. The procurement of school uniforms has to be done mandatorily under the GEM portal and not under the e-portal. Next para. Mr. S. Bora, the appearing for the Sarva Shiksha, submits that the matter may be listed tomorrow as the learned AG will be appearing on behalf of the respondent. List the matter tomorrow. But then can we
by Friday, Lordship.
You have it, you'll have to list the matter tomorrow. Huh?
Friday, the Lordship date finalized, Friday they will finalize.
But tomorrow
it may not reach, Lordship.
He'll come to this, he'll come supplementary.
Not here.
He'll come here. This will take time because I know you all will take time.
Lordship.
Or I can do it also, I can just.
First item, Lordship.
Already 10 motions. Those are the. 50 are the.
I'll try my luck, Lordship.
What?
Before your Lordship.
No, I won't have time.
We haven't already finished.
Sorry. I can. Nothing will happen, Lordship. Supply will be made in the month of March, April. Now, Lordship, they will open this tender, 29.
So let him come day after. Let him do it day after.
Lordship will not pass any stay order, but it can be, but let it be tomorrow in any other branch, my lord. If he is appearing,
AG is appearing, day after tomorrow, they will vacate the order. Till day after tomorrow.
What's
Tomorrow
pass any
is going to
order,
open.
Till we
day after
the appropriate then
This is the matter of Friday. Till then. The till then, the bids of the tenderers should not be.
Obliged.
finalization finalization should not be made, that
Till
finalization should not be made, that tender may not be open because in 3 p.m. it is going to open.
but they want to participate.
It will be infectious.
They want to participate.
Obliged.
On the last occasion, there's a direction to produce this videograph.
There is. You're okay.
Section of 59.5. I've got a section for 50 adjudication. So the guy.
Okay, so that's the thing. This is the box, steel box. This is the cabinet. How to open it?
Lordship, that is not the cabinet, that is the box where the video was stored for it.
Correct, that is the, so how to open this? Open
This is the seal which was placed in the first meeting. Then it was opened on that day on the. The point meter is inside.
So the deep thing is the cabinet. So this is what you think that can be opened.
That is the cabinet.
So that is the cabinet that can be opened, that's what you're saying.
Cabinet, where the picture was, it's in the cabinet box. The picture is installed. That was found intact. They could not have tampered with the evidence authority has said the cabinet box is sealed on one side. This is on the other. So the interest can easily be removed, the window tampered, the interest can be removed.
But that's what interest is.
So what your lordship has for your lordship, the burned thing, that is the meter. The cabinet box your lordship and the meter is included, that has circuit people installed that is clearly
There are two openings. So the outer one is the one that the picking of which has stitches that we open. There are two capitals.
yes. For example, in the two doors are yes. The ticket from the elements because it will be outside the house.
So which one can be opened?
The cabinet door can be opened.
The outer one or the inner one?
The outer one. That is the outer one, the cabinet door, that is
There's not much time. We'll hear it on the after vacation because it takes time. I want to see it once more. I think from unless someone puts it inside, it cannot be there by on its own. That's what.
and if a foreign circuit is there inside the meter, the presumption will be that it will be there to reduce the reading. Nobody will insert a foreign circuit to increase the reading of it. Because since the meter was burned, completely burned, what the circuit actually did or could have done, those are things that we now cannot assert.
Anyway.
Otherwise, keep the pen drive on record because I have made a copy of this provided by the
You make why should we keep it? You keep
Yes,
on,
yes, very well.
you keep it on record. It's a burden for us.
Very well.
Correct. Right, Mr. J.S. Sawana, Senior Counsel for the petition. As well as Mr. K.P. Pathak, Learned Counsel for the APDCL. The APDCL has also produced a video graph of the physical verification of the meter undertaken on 29/1/2016. This is the matter again after the vacation. What date, you want a date? After the Bihu vacation, this is the matter after Bihu.